Oh, good morning. Good morning, good morning. Thank you all for being here. My name is Ben Trachtenberg, and I'm the Associate Dean for Academic Affairs here at the MU School of Law. Professor Drake, Professor Reeves, I appreciate the opportunity to be with you this morning at this fantastic symposium. To everyone joining us, whether you're one of the 209 people who registered in advance to attend remotely, or about the 100 or so who registered to be with us in person, or people who don't believe in registration but just showed up. Welcome you all. Let me welcome you on behalf of Dean Larissa Lidsky, who's traveling this week. She asked me to express her regret that she could not be here in person and to thank everyone who put in so much work into making this event happen. I realize that most, if not all of you, are familiar with the work of the Mizzou Law Veterans Clinic, but I cannot resist the opportunity to briefly brag about its work. Each semester, the clinic enrolls students who assist real clients. These clients are military veterans and their families, and the clinic helps them to secure disability-related benefits. Professors Angela Drake and Julia Reeves are licensed attorneys who oversee this student work. Since beginning in 2014, the clinic has directly assisted hundreds of veterans clients. By working on real cases, students gain practical experience that supplements their classroom learning. Because the clinic is there, veterans get benefits to which they are entitled, but they otherwise might be denied. So it's a win-win. And if I can say so, it's actually a win-win-win. I say this because in addition to teaching our students and helping its clients, the clinic helps to educate the broader community about veterans law. With its annual symposium, the clinic gathers experts to share their knowledge with practitioners and others interested in the field. Recent topics have included judgment and courage, the role of attorneys in critical military and veterans issues, and Veterans Appeals Improvement and Modernization Act of 2017, finding footing, which, as we'll discover in the not-too-distant future, that footing is still being sought. In addition to providing free CLE credit, which is nothing to sneeze at and presumably has encouraged some attendance from the local bar, this year's symposium continues the clinic's tradition of sharing information about the latest events in veterans law. Our topic is pushing the envelope, first in advocacy for America's heroes. As usual, we have an impressive lineup of speakers, which includes our own Professors Drake and Reeves, along with honored guests. Today, we will hear from Mel Bostwick, Amy Odom, Professor Amy Krakowski, Bart Stichman, Captain David Rogers, Lieutenant General Richard Harding, Captain Janelle Murphy, Joe Neely, and Lieutenant Larissa Tiller. Seeing Captain Murphy and Lieutenant Tiller on the speakers list is especially gratifying because they are both graduates of Mizzou Law who worked in the clinic. So if anyone needed evidence that our clinic students are taking the skills they learned at Mizzou out into the working world, we have living proof with us here today. Our speakers will address veterans advocacy at the highest levels, as well as tough, difficult to navigate terrain of legislation and advancing technology. We'll hear also from JAG officers about legal challenges facing current service members. Before we turn to the 9 a.m. panel, I would like to thank some of the many people who made this event possible. First, our speakers are Mollring and Ambler. Our sponsors, are Harper, Evans, Wade, and Nedemeyer, Eng & Woods, Giovello, and the Alberhaskey Law Firm. Thank you all for your generosity. It's important to the law school to offer this symposium at no cost to attendees, and financial support from sponsors is essential to doing that. In addition, clinic staff have worked tirelessly behind the scenes to prepare for today. I'd like to thank Eugene O'Loughlin, Martha Bradley, Nikki Ettinger, Mary Firking, and Mary Austin for all of their hard work. Beyond clinic staff, other law school staff have helped with logistics, including Terry Potter and Daryl Yeager. If I have left anyone out, which I surely have, I apologize. That is the risk one takes when one begins enumerating specific people who are worthy of praise. But I wanted to make sure I mentioned at least some people for their hard work, and just keep in mind that there are others who deserve to be mentioned as well, and I'm sorry for that. Our program today will begin with a panel entitled The Black Hole of VA Adjudication, which concerns the aforementioned Appeals Modernization Act. Then we will hear about the wrong stuff, which I'm told may be found from time to time at the Federal Circuit level. After a break, we'll have lunch and then hear from our keynote speaker, Bart Stichman, or maybe even have lunch and hear from him at the same time about, well, maybe we'll hear from him and then eat. Thank you, Professor. And we'll hear from him about the right stuff. So we're covering all the stuff, right and wrong. The right stuff will be focusing on innovation in veterans advocacy. Then we'll turn to smooth cruising in the clouds, covering the ethical duties of virtual lawyers, a subject, of course, that has gotten more important than ever in the past year or so. And after our final panel, moderated by General Harding, we'll hear closing remarks from Professor Drake. When I first came to Mizzou, this clinic did not exist, and when it came into being, it just seemed like such an obvious extension of the mission of the university and the law school, and indeed, a continuation of the purpose of universities in general, and even of the country. I mean, if you think back even to the days of Pericles, he mentioned that his own ancestors had long ago said that it was important to take care of veterans and their families. And it was one of the basic building blocks of running a civilized society, that the people who fight for a country, particularly those who volunteer, and who volunteer to fight for a country that purports to be a government of the people, for the people, and by the people, well, we, the people who govern, owe a duty to those folks who help make sure that the country can continue to exist. And this clinic gets up and makes sure that the public money that has been promised to veterans and their families is actually delivered to them so that they get the benefits that they have earned. And so every day when the students go in to work at that clinic, and when the faculty members who supervise them and the staff members who assist them, they know that they're helping this country and this university perform a vital duty that is essential to what this country stands for. So I want to thank everyone for being with us here today. Again, I'm honored to welcome you here, and I look forward to the day's presentations, which will now begin without any further delay. Thank you all very much. Welcome.
Hello. Oh, good morning. My name is Emily Bergman, and I am a 3L student here, and I am in the Mizzou Law's Veteran Clinic this semester. I became involved in the Veterans Clinic to gain invaluable practical experience and passionately advocate for veterans. We are pleased to welcome back Amy Krotowski and Amy Odom. Both of these women are strong veterans advocates with a wealth of knowledge, experience, and charisma. Amy Krotowski obtained her Bachelor of Fine Arts from NYU's Tisch School of the Arts in 1988 and obtained her Juris Doctorate from the University of Iowa College of Law in 2008. Before moving to Iowa to practice law, she spent 18 years as an independent writer and producer for television in New York and Los Angeles. Ms. Krotowski began her career in veterans law in 2009 as a judicial law clerk to Honorable Mary J. Sholin on the U.S. Court of Appeals for Veterans Claims. She currently works in her own veterans law practice in Iowa. She also serves as an adjunct professor at the University of Iowa College of Law, where she teaches upper-level courses on veterans benefits law. Since 2011, she successfully represented hundreds of veterans and their survivors in their appeals for VA disability and pension benefits at VA regional offices, the BVA, and the CVAC. Ms. Krotowski lives in Iowa City with her husband, Paul, and an emotionally unstable husky mix named Ruckus. Amy Odom graduated from the University of Florida with her Bachelor of Arts and Juris Doctorate in 2003 and 2006, respectively. She previously served as a staff attorney and is the Director of Litigation at the NVLSP. She served as president of the CAVC Bar Association and on the United States Court of Appeals for Veterans Claims Judicial Advisory Committee. She is a credited author of multiple editions of the Veterans Benefits Manual, the holy grail of veterans benefits that we use at Mizzou Veterans Law Clinic. She's trained countless attorneys on veterans benefits advocacy, including our own Professor Angela Drake. Ms. Odom currently serves as the Appellate Coordinator for Veterans Law Practice at Chisholm, and Kilpatrick, a premier veterans law group. Ms. Odom enjoys spending time with her husband and 2 daughters. This is Ms. Odom's 7th time speaking at our symposium, and we hope to have both her and Ms. Kratowski back for many years to come. Amy and Amy will be speaking on the black hole of VA adjudication, successes and setbacks following the Appeals Modernization Act. After they speak, we will be taking questions and answers. Thank you.
Thank you. Just wanted to make sure that people can hear us, and I think Amy wanted to make sure that we can see the PowerPoint presentation. So I got a yes here from the director's station, so I'm assuming that you can see the PowerPoint presentation, so I'll just jump right into it. I would really like to start off by sending a great big thank you out to Angela Drake and all of her students who have made this symposium possible. It's a real honor to be here again, and truly a magical experience to be talking with Amy Odom and being able to work with her on this presentation. We've been able to have some very interesting conversations back and forth about this material. We're both having certain feelings about the AMA more than 2 years in, and so I'm happy to be here. And on behalf of Amy and myself, I just want to thank everyone for putting this together. We've got quite a bit of material to cover. I'm going to start off with just giving sort of a broad overview of the AMA, and then hand off to Amy, and she's going to talk about more recent cases that are in the that came out of the Federal Circuit and the Veterans Court dealing with AMA issues. And then she's also going to talk about what's coming down the pipe in terms of cases that are currently before the Veterans Court, including one of my own. And so we'll wrap things up there. So the first slide that we've got here that I'm seeing is a quote from the Andrews case that recently came out, and it's actually quoting NVLSP's Veterans Benefits Manual, which, as Emily was saying, it is the Holy Grail. I call it the Bible. Amy, went out and wrote it. I went out and bought it. And if y'all aren't using this, and if you're practicing, you should be using this. This is an incredible resource.
Full disclosure, I did not write this line, which is absolutely beautiful.
Okay, who wrote this line? Do we know?
This was probably Bart Stichman, the keynote speaker today, or
okay, beautiful.
Rick Spataro of NVLSP.
Okay, well, it is a great line, and it is, was adopted in this decision, and I think has probably been quoted in many other briefs and decisions already. I know that I've already quoted this in 2 briefs since the Andrews case came out. So it's a really it sums it up nicely, as well as the heading here that it is a mad AMA world. Let's go to the next slide. So this slide just sort of shows an overview of the whole decision process under the AMA as of February 19, 2019, which is when this new system went into effect. So I'm going to go into a little bit more detail, but I just wanted to sort of lay out the whole new system here. It starts out with the claim, and that establishes the effective date. The veteran files a claim, and that establishes the effective date. And at that point, the duty to assist is in effect in full force, and it applies up to the point the VA issues a decision. Once VA issues a decision, then the veteran will have 1 year for all appeal options to appeal, to go either to what's in the green column or the red column. If you want to appeal within VA, within VBA, at the agency level, you can ask for a higher level review or submit a supplemental claim. I've got the form numbers there. Higher level review, no new evidence. You can submit additional argument. You can have an informal conference. I'll talk about that a little bit more in a moment. Supplemental claim, you can submit evidence, and the duty to assist applies again. If you don't want to deal with the regional offices anymore, and you want to appeal directly to the board, that's your third appeal option. You can file a notice of disagreement. There's a new form number for that. And there's 3 separate lanes that you can appeal at the board. And you need to be very careful, particularly in light of some new case law, about which lane you're going to appeal when you go up to the board. Let's go to the next slide. Okay, so here are some statutory highlights of the AMA. The first one is really critical. You can preserve your original effective date if you appeal any decision that comes from the RO, the board, or the Veterans Court within 1 year of that decision. I think that was a pretty a substantive response to people being concerned about losing the effective date, the appropriate effective date, by appealing up to the court. If you get a decision from the court, from the Veterans Court, and you can appeal that decision within 1 year. You can file a supplemental claim within 1 year and still preserve your initial effective date. The next highlight is the new and relevant evidence standard, which Amy's going to get into in a little bit. The next highlight, which I think is very important and really critical to pay attention to, is that favorable findings are binding on all the subsequent adjudicators down the line, unless there's clear and convincing evidence that those favorable findings are wrong. I would advise you, getting a decision, to really read those favorable findings very, very carefully. Amy and I spoke about this last night. I actually received a decision that had favorable findings that would establish entitlement to service connection. And I ended up filing a request for higher level review because there was no reason for the denial when the favorable findings listed, there's a current condition, there's an in-service event, there's a medical nexus between the two. And I was like, well, so what's missing? And I filed a higher level review, and I got a decision back on that saying, oh, no, sorry. One of these favorable findings was clear error. And so they turned it around. So be careful about reading the favorable findings. All right, let's go to the next slide. Okay, so I mentioned these new appeal options, which we'll go into in a little bit more detail: higher level review, supplemental claim, notice of disagreement. The deadline for all of them, 1 year from the date of the decision. Missing from this, for those of you who have been around before the AMA, is there's no more statement of the case or supplemental statement of the case, and there's no more requirement for a VA Form 9 to perfect your appeal, to continue to go up to the board. This, I think, is, so far, I think this is actually a good thing, because I think the whole statement of the case and the VA Form 9 confused a lot of veterans. So I think this is actually a pretty good part of the AMA. Let's see the next slide. Okay, so for higher level review, the first option on appealing a denial from the regional office, or appealing a decision that you don't like any aspect of it. If you get a decision that assigns the wrong effective date, or assigns what you think is a low rating, you can appeal that as well as an outright denial of service connection. So higher level review is a de novo review that is based just on the evidence that was in front of the agency at the time that they made that original decision. You can't submit any new evidence. And when they issue that decision after doing the higher level review, they have to indicate if there's any evidence that was not considered. So if the veteran submitted evidence after the date of the decision, they're supposed to identify or say that there was evidence that was not considered because it came in afterwards, and explain how the veteran can get that evidence considered on further review. Which is always, they're always going to say file a supplemental claim if you want this additional evidence submitted. Let's go to the next slide. So higher level review is conducted by the DROs. It's the former decision review officers are currently conducting, for the most part, higher level reviews, and so they're supposed to be more experienced adjudicators who didn't take part in the prior decision. And it's usually from a different regional office, although you can ask for the same regional office if you want to. And VA will generally grant that request. And you can also ask for an informal conference with the decision review officer who's going to ultimately make the decision on the higher level review request. I initially, when this first started, I had a couple of not great experiences with the informal conference, and so I stopped doing them, and then I started up again. And I've since had some better experiences with the higher level review informal conference. And there's I guess it really depends on what you feel is in the record, what you feel the error is that was made in the decision. And if it's something that you can talk with someone about, sometimes it's just better to get someone on the phone and explain to them why you think their decision is wrong. And in a few situations more recently, having this informal conference has been helpful. Let's go to the next slide. Okay, so like I said, I was initially sort of hesitant on the higher level review, but these are situations that I've been using when I sort of want to think, okay, when am I going to choose higher level review? It's pretty easy to figure out when you're going to choose to go the supplemental claim lane, right? Because if you know that there was other evidence that you have now that you want to submit, that you want to get them to consider, that makes sense to choose the supplemental claim lane. Choosing higher level review, it takes it's not that straightforward. I generally want to be able to identify a very clear error. The DROs now, I think, are less empowered, right, than they used to be. They used to be able to do, seems to me, they used to be able to do all sorts of things that they can't do these days on higher level review. Higher level review, it seems to be that they can really only turn things around if there is clear error. And so some of these errors that I've noticed that I've been able to successfully have an informal conference and get them to turn the decision around is assigning the wrong effective date. I see this all the time with TDIU, with total disability rating based on individual unemployability. They will, the regional office generally will assign the effective date as of the date that they receive the TDIU application, which if they receive that application during the pendency of an original claim or during the pendency of a request for an increased rating, that the date of the application is not necessarily the correct date for the assignment of TDIU. The request for TDIU is not a separate claim. It's part of the underlying claim for service connection for an increased rating. It's an attempt to get the appropriate rating. It's not a separate claim. And the regional offices generally, if they see an application, they'll assign the effective date as of the date that they receive the application for TDIU. And that's pretty easy to turn around, I have found, on higher level review. More recently, I had a case where the RO assigned a low rating for a condition, but there was an alternative diagnostic code that I felt should have been considered. And this was one of the cases that, maybe a year ago, I probably would not have done higher level review on, but I rolled the dice and I did higher level review and it paid off because I had an informal conference and the DRO agreed when I pointed out what was in the CMP report, what was, at the time of the decision, what was in the VA exam, what was in the medical record, the evidence that was in there that supported that the assignment of this other alternative diagnostic code, which would get the veteran 100% rating versus the diagnostic code that they assigned a 30% rating. And so that was, it might not work in all situations, but it's just something to think about. Obviously, if they don't consider favorable evidence of record, that you can point out to the decision review officer and get a new decision based on consideration of that new evidence. If they fail to consider an alternative, either expressly raised or reasonably raised theory of entitlement, if they deny on a presumptive basis, but maybe they could have granted on a direct basis, or if they deny on direct and could, or 1151, and they could have granted under secondary. I've seen that quite a bit. If someone has a condition that's a result of treatment for another service-connected primary condition, and filed a claim and said, under 1151, they wanted to get benefits, and they're denied under 1151, but because they were having treatment for a service-connected condition, developed a secondary condition, the RO should have considered entitlement to service connection on a secondary basis. The failure to consider that alternative theory is the sort of error that can be turned around on higher level review. The failure to adjudicate or defer an expressly raised claim. So if your veteran filed a claim for 5 different issues and they only addressed 4 of them, that needs to be pointed out. I think you can point that out at the decision review to the decision review officer. And a very clear misapplication of the law is something that can be turned around on higher level review. All right, let's go to the next slide. Supplemental claims. So here's where we're going to have a little bit of fun on this one. So the supplemental claim is what you'd want to submit if you have new and relevant evidence. So if you got new and relevant, you get a decision, it's a denial. 3 months later, you get a favorable nexus opinion. You'd want to submit a supplemental claim, and if you do so within the year, you can preserve your entitlement to that initial, the original effective date that's resulting in the first denial. It has to be the new and the new evidence has to be relevant. And then the next adjudicator will consider that evidence, and it's not supposed to present a higher evidentiary standard. But I'm going to toss over to Amy to make a few points about this new and relevant, not to be confused with new material, or maybe to be confused with new material. But Amy's going to explain it all to us.
Well, I don't know about explaining it all, because I think that the fun part of this conversation is that we really don't know what relevant means quite yet under the AMA. And it's a pretty, because that's going to tell us whether we can get a claim re-adjudicated and keep that effective date, which is, the highlight of the AMA for veterans and their advocates. So I've taken a look at a few things, and I think that we have 3 possible standards for what relevant means under the AMA. And there's like a high, middle, and low standard. And the high standard comes from this case called Kaiser versus Wilkie, which is not even an AMA case. It was about a different regulation that applies when VA receives official service records. So like service medical records or unit histories or something like that existed at the time of a prior denial, but wasn't associated with the claim at that time and not considered. And that regulation says that VA will reconsider the previously denied claim if the records are relevant. And Kaiser, the Federal Circuit said that relevant in the context means that the records have to reason why the claim was denied. So in that case, a Vietnam veteran filed a claim in the 80s for a nervous condition, is what they called it back then. He went to a VA exam and told the examiner that he had participated in Operation Harvest Moon, which was a combat operation. But the examiner diagnosed him with a personality disorder and said that there was no acquired psychiatric disability related to service. So VA denied the claim the regional office denied the claim based on the lack of a diagnosis. And the Federal Circuit noted time there was evidence in the record that he had participated in combat, his statements to the VA psychiatrist. But those of us who have been doing this for a long time, we know the office, especially in 1983, would never have accepted this veteran statements as evidence of combat, like establishing combat, unless there were service records that corroborated that. Well, guess what? There were service records that corroborated that. And many years later, the veteran submitted them to the VA and said, okay, now reconsider. I have. The circuit said, no, those are not relevant records, because the reason why the claim was previously denied was not because they didn't believe that you were in combat or that you didn't have an in-service psychiatric injury, but because you didn't have a diagnosis. To be relevant, the evidence has to relate to the reason why it was previously denied. That's a pretty high standard, especially when you consider what is the definition of material evidence under the legacy system. Under the legacy system, you could reopen a claim only with new and material evidence. Called Shade versus Shinseki, the Veterans Court said material just means it has to relate to a previously unestablished element, which seems a little different than the reason that the claim was last denied. It doesn't have to be something that was like an act. In fact, that's what VA explained in the Federal Register and the regulatory history for the new and material regulation. It doesn't have to the reason why it was previously denied. It just has to relate to a previously unestablished element. And you have to look at that evidence and make a determination as to whether, based on that evidence and VA's assistance in getting a medical opinion or some other kind of records or evidence as part of the duty to assist, it would substantiate the claim. Amy and I talked about it yesterday. We think that means that Mr. Kaiser would have prevailed if under a new and material standard. Tell me if I'm misspeaking, Amy. Do I need to speak for you?
No, I think you're right, because under new material and particularly under Shade, like you said, that it doesn't have to, the new evidence doesn't have to cover every single reason, or even it just needs to relate to, a reason, it just not a reason, an unestablished fact necessary to substantiate the claim. Just it says an unestablished fact, not a reason for the denial. It just says an unestablished fact. And Shade also says that it has to be, that evidence has to be looked at and thinking in terms of, would this evidence help substantiate the claim if we were looking at this in the context of the entire record and considering VA assistance, with VA assistance. So in Mr. Kaiser's case, like you had mentioned last night, if they had that Operation Harvest Moon documentation, then maybe they could have gone and gotten a better, a medical opinion from a doctor showing, hey, he had participation in this combat operation. And so maybe the doctor would not have rejected the credibility of what he was saying, right? And so that's Shade. And so yeah, and I think, where we went back and forth, and I'm still confused, is there a difference between the standards for 3.156A versus 3.156C? But that's for a whole other.
Right. Well, Kaiser makes it seem like it is. Kaiser makes it seem like 3.156C is actually higher than material under 3.156A, the way that the Veterans Court interpreted material. This is because there's a footnote in Kaiser. They dropped a footnote, nothing to do with A, and had nothing to do with new and relevant evidence in his claim. They dropped a footnote saying, this is consistent with this new rule that we have AMA to submit new and relevant evidence to reopen a claim. So that, you can read that as not really saying much, or you can read that as being very important and signaling Federal Circuit believes is the standard under 3.2501A. So here comes the fun part. So that's, the high strict standard is kind of the reason why I got into what's new and material is because Congress in the legislative history says that relevant in the AMA is supposed to be lower than material in legacy. So we've got that middle ground. Like, it's not as Heiser says it is, and it's lower than material, which is what I intuitively would think is that the term relevant necessarily implies something lower than material. And then you're going to love this. We have the lowest possible standard, which comes from the VA itself, and it's VA adjudication procedure, which is online. They have a provision that says evidence that confirms a prior favorable finding can still be relevant. So that means if your claim was denied because you had an in-service, there was a favorable finding that you had an in-service knee injury, but you did not have a diagnosis, and you had a diagnosis, but there was no link. So we have two favorable findings. One, current diagnosis, service injury, but unfortunately we don't have any medical evidence making the link. VA's procedure says new evidence confirming the diagnosis is still relevant and is sufficient to reopen the claim. That's low. That's way lower than material. That is very, very low. There's an argument that this is VA's official interpretation of the term relevant in 3.2501. And so my advocacy tip on this point would be that if you are pursuing the regional office, point to the M21 and make the argument that that's the standard and that new evidence confirming a prior favorable finding is still relevant, because the ROs by law are bound by the M21. The board, however, is not. The law has that right. They can say that they disagree with the interpretation as set forth in the M21, and if they have an adequate discussion, an adequate statement of reasons or bases for why they disagree, the courts at this point seem to say that that is legally allowable. So if you're at the board and you're still having to fight over whether your evidence is relevant, another advocacy tip I would have is to make the argument that if it's not in a favorable finding by the RO in the prior decision or decision, then it's an issue in dispute, even under the highest standard under Kaiser, because now VA is statutorily required in AMA to list all of its favorable findings. So every resolves in the veteran's favor, it has to list in the decision. That means if it's not listed, then it wasn't really veteran, it's a dispute. So if you can point to those favorable findings and say, look, evidence about is not in these favorable findings and it's issue and dispute, that should get you over that highest relevant standard.
That's a pretty huge point to make on this, and I swear, the next time you do the symposium, maybe the Supreme Court would have granted cert on the when was you said what the petition was filed just last month?
Right. So the petition for cert in Kaiser was filed in September, and for those who are not really nerdy like Amy and I, this would be the second time that Kaiser has gone up to the Supreme Court, which in our world, in veterans law world, is like the Super Bowl because it hardly ever happens, right? It's already been up once about whether VA was entitled to deference, its interpretation of relevance under 3.156C. Ultimately, the Federal Circuit did not accord deference to the VA's interpretation. It sidestepped the issue by saying that relevant has a plain meaning meaning, so they didn't have to defer to any interpretation. And so now it's going to go back up, hopefully, if the court grants cert on whether that was right, whether that the Federal Circuit's finding that relevant was plain on its face was correct.
So hopefully we'll be able to come back and talk with you about this next year with
I
much
would love
better
that.
news. All right, we can spend forever on the supplemental claim, new and relevant evidence, but let's just move on to the next slide so I can start wrapping up this this top portion. This is another key element, a key feature of the AMA is that you can separate issues. So if a veteran gets a decision on 3 separate issues, the veteran can conceivably request higher level review on one issue, submit a supplemental claim on the second issue, and appeal the third issue to the board with a notice of disagreement. And that's, buyer beware with that one, because then you've got really to keep track of, you got a lot of balls in the air that you're juggling. And so you really need to pay attention and keep track of that. Let's go to the next slide. You can change your review option within 1 year of the initial decision, and you can change it to the supplemental claim after a year if you get an extension for good cause under the regulation, and the supplemental claim is received within the extension period. And so that's at the agency level. Let's go to the next slide. So your options for review after you get a decision on your request for a higher level review, you can't request another higher level review, but you can file a supplemental claim with new and relevant evidence, or you can go directly to the board with a notice of disagreement. After a supplemental claim decision, you've got all 3 options open to you. You can file higher level review, you can request higher level review on the decision on your supplemental claim, or you can submit even more new and relevant evidence with a new supplemental claim. You're still preserving your the earliest possible effective date if you're doing all of this within a year, or you can file a notice of disagreement directly to the board. Let's go to the next slide. Okay, so this slide talks about the different board dockets, and so there's the direct review docket. If you think that there's a clear mistake that was made, it'll go to the veterans law judge, and that law judge will make their decision based just on the record, just on the evidence that was in the record at the time of the prior decision. The goal for the board is 365 days. I think they're not meeting that goal right now, but that is still the goal. If you want to submit new evidence to the board to consider, so say you don't want to do a supplemental claim, but you want to submit new evidence right to the board, you check the evidence review lane, and then you have a certain period of time, I believe it says 90 days, to submit that new evidence. And the veterans law judge will review that evidence in the context of the entire record and make a new decision. If you want a hearing, oh, good luck. You're going to be waiting forever and ever and ever, a really long time. I can't remember. Cheryl Mason said, the chairman of the board said at the NOVA conference that they were, do you recall what it's 2 years to wait for a hearing? It's just a very, very long time that you're going to wait for a hearing. Okay, so let's go to the next slide. So board remands, this slide just talks about the difference between board remands under the legacy system versus under the AMA. And this, I work with a lot of the VSOs here, and this is something that has been confusing to people, because they expect when they get a board remand that if VA is going to continue to deny, they're going to issue an SSOC, a supplemental statement of the case. And that's what happened in the legacy system. That does not happen anymore under the AMA. If the board remands and the regional office is still going to deny, they're just going to issue a new decision. And guess what? You got a year to appeal that decision. and you don't get to, even if you appeal and you select notice of disagreement, you want to go right back to the board, you go to the end of the line. You don't get your same spot on the docket like you used to under legacy. So this is I'm not entirely keen on this aspect of the way board remands are treated, but this is what the system is now. Let's go to the next slide. So a duty to assist error, when the board remands saying that the regional office made a duty to assist error, and this would be an error that's found, prior to the issuance of that original denial. If they made a duty to assist error, that opens the record. And so once that record's open, you can submit additional evidence as well. And that becomes part of the evidentiary record that has to be considered when the AOJ goes and re-adjudicates the claim. Okay, let's see the next slide. Okay, I emphasize this. This is just that remands don't automatically go back and that the veteran loses his place. This is, this can be confusing to a lot of people, particularly people who were, very familiar with the older system. All right, next slide. Options for review of board and CAVC, Veterans Court decisions. So after you get a board decision, say you get a board denial, you can file a supplemental claim with new and relevant evidence within a year of that decision, and you still get the original effective date, the effective date of that was related to the decision that went up to the board. You can still, within 1 year, if you file a supplemental claim, you can get that effective date. You can also still file a notice of appeal to the Veterans Court within 120 days. After a court decision, this I think is really the true benefit of the AMA, is that you can, if you get a bad court decision, you can file a supplemental claim with new and relevant evidence within 1 year of that court decision and still preserve the earliest possible effective date. Or you can file appeal to the Federal Circuit. And that's all I have on the AMA. So I'm going to, unless there are questions, or we're going to take questions at the end, I'm going to shut up now and toss it over to Amy to tell us about some new and noteworthy cases from the courts.
Okay, great. Thanks, Amy. And we'll see you back for Rettinger, right? Okay. So the first case I'm going to talk about is one that actually came out relatively recently. It's called Military Veterans Advocacy versus the Secretary. This was a petition for direct review of rulemaking up at the Federal Circuit. And a couple of veteran service organizations, a law firm, and an individual veteran that challenged several regulations implementing the AMA. Ultimately, the court found that the organizations and other petitioners only had standing to really challenge 3 of them. The first one was 14.636, which purported to limit when a veteran's representative could charge fees for work on supplemental claims. The second was the regulation that barred filing a supplemental claim while on a claim that was also being litigated up at a federal court. So like the Veterans Court or the Federal Circuit, or when you get to the Super Bowl once in a lifetime, the Supreme Court. And the third one was a regulation that excluded supplemental claims from a process that VA has that you can file a form called an intent to file form and just say, hey, just heads up, I'm going to be filing a claim for benefits within the year. And if you do actually file the designated claim form within a year of that intent to file form, you get the effective date of the intent to file form. Here's the good news. The court struck down the validity of all 3 of those regulations. They were all invalid and inconsistent with the statute, is what the Federal Circuit said. So this means that you can charge a fee on any supplemental claim, or attorneys can charge a fee on any supplemental claim. The problem was that VA had said there are two types, or actually Congress had said there are two types of supplemental claims. There's the type of supplemental claim that you file within a year of the denial, and the continuous prosecution supplemental claim. And then there's a supplemental claim that you file more than a year after the denial. That's not continuous prosecution. The difference really is the effective date. You still have to submit new and relevant evidence on both of them. But the difference is if you file within a year, you keep that effective date. If you don't, the effective date is the date you file the supplemental claim. The attorney's fee statute, which previously said that attorneys could only collect a fee after a notice of disagreement had been filed, has now been changed to say attorneys can only collect a fee after an initial decision on the case. And the reason why is that you don't have to file an NOD in every case now. You can submit a supplemental claim. You can request a higher level review. Your only option under legacy to continue pursuing a claim was to file a notice of disagreement, but now under AMA you have different options. But the VA's regulation said there's a difference between the supplemental claim that you file within a year and the supplemental claim that you file afterwards. And you don't get fees on the one that you file after a year until we have a decision on the supplemental claim. You can get fees if on the one that you file within a year, even if it's a grant and we don't issue a new denial, but you have to have a new denial on a supplemental claim that you file after a year in order to get fees. Court said, no, that doesn't make any sense, and struck it down. The other one, the regulation said you can't file a supplemental claim and go to the Veterans Court or the Federal Circuit at the same time. Again, the Federal Circuit said there's no support for that in the legislation. In fact, it seems inconsistent with the legislation, struck that down as well. And then VA said, because of the effective date statute, we can't let you file an intent to file on a supplemental claim. You have to, for continuous prosecution, you have to file the supplemental claim form, and you only get the effective date that goes to the supplemental claim. We can't allow you to file an intent to file and get that effective date. And again, the Federal Circuit said no. There's no reason why the legislation wouldn't allow that, and it's therefore inconsistent with the legislation, and struck it down. So this is the first major case that we've had striking down AMA regulations. And it was a slam dunk for veterans and their advocates. Andrews versus McDonough, not so much a slam dunk for veterans and their advocates. This case addressed a question that was really left entirely open by the AMA, which is what happens when you get a remand from the Veterans Court? Can you submit new evidence? Under legacy, there was no question that you could. Once you got a remand from the Veterans Court found that the board had committed some sort of error and vacated the board's prior decision and remanded the appeal for a new decision. There was no question that you were allowed to submit new evidence that the board had to consider. And that's because at basically virtually every step along the way in the legacy process, the veteran was entitled to submit new evidence that the VA had to consider. And that the Federal Circuit touched on a bit, and MVA, the case we just discussed, did account for some of the delays that we saw in the processing times in the legacy system. So in Andrews, the veteran had a board decision on his knee ratings. Didn't agree. Well, on the way up to the board in AMA, he selected the direct review docket, which means that he said, I don't have any more evidence to submit. I just want the board to decide my claim. Just go ahead. So the board under the statute then was limited to reviewing only what was before the regional office on the initial decision, right? So the record closed. So he gets a denial from the board, goes up to the Veterans Court, as is the case in the majority of the cases at the Veterans Court. The Secretary's counsel agreed that there was an error and that the board's decision should be vacated and the claim remanded for a new decision. But this is where things went awry, because in legacy, we would always have language in the joint motion for remand that would say, on remand, the veteran is entitled to submit any new evidence and the board must assist him in developing the claim and yada, 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 because that was just the rule. They wouldn't allow the language. The secretary would not allow that language in this case because the secretary said, you are now an AMA, and under AMA, the board is limited to reviewing what was in the record at the time of the initial decision on, the initial claim or the supplemental claim, however it got up to the board. And there's no duty to assist for the board anymore. So we're not including that language. So then, even though all the parties agree that there was an error and the case had to go back, it still went to a panel of the Veterans Court for a decision on whether they should put this language in the JMR at all. And here are some cases in the legacy system that created the basis for the language that we would have in legacy JMRs about submitting new evidence to the board. There's Fletcher and Kucharewski. And the Veterans Court said, those cases don't apply anymore. We're in a new system, just like that quote we saw at the very beginning of the presentation from NVLSP. It's a whole new world now. It's a brand new adjudicatory system. And the legacy, don't expect the legacy rules to apply because they don't necessarily apply to this new system. And one rule that doesn't apply is that you have an automatic right to submit new evidence once you go back to the board from the court. The specific reasoning in Andrews was that the veteran selected the direct review lane on his way up to the board, which means he was not allowed to submit new evidence to the board. And those were the rules that he had to abide by going back as well. So one advocacy tip is there's some who argue that, right, but Andrews is limited to when you choose the direct lane going up and you're not allowed to submit new evidence to the board. But if you choose the evidence lane or even the hearing lane, you get to submit new evidence when it goes back down. So you should always choose the evidence review lane on your notice of disagreement just in case. I personally am not entirely convinced by that argument because if you read the Andrews rationale carefully, I think, in my opinion, what they're saying is the deadlines that apply and the rules that apply under AMA apply even when you go back to the board after the court. And the rules under the AMA before the board say that you can only submit, even if you choose the evidence lane, you can only submit evidence within it's like 60 or 90 days of your notice of disagreement. That will have passed a long time ago by the time you get a decision from the board up to the court and then back down to the board. And if you're stuck with that deadline, that means you still can't submit new evidence. So that means that arguably the only way that you could submit new evidence to the board once you come back from the court is if you've argued that your hearing was inadequate for some reason and the court orders a new hearing. Because if you selected the hearing lane, you get to submit evidence at the hearing and within 60 or 90 days from the date of the hearing. So that would reopen the evidence submission period. But those cases are few and far between. Like that is a very special situation that you have to be able to make that argument and succeed on it. But good news, here is the beauty of the AMA. If you have new evidence that you want to submit that you think is really going to make or break your case, just wait for the board to deny it, file a supplemental claim with your new evidence. There's no reason in legacy, the claim was over. The case was over. Once you got that board decision, unless you had a reason to go back to court, that was it. You were done. You had to submit a new claim and you were stuck with the effective date of the new claim. MA, it's not over. It ain't over till it's over. So even if you get a bad board decision and you've got evidence that you think is going to be really the smoking gun here, you just submit it once you get that board decision in the supplemental claim lane. Also, if your remand from the Veterans Court is for the board to remand to the regional office to correct a duty to assist error, like they got an inadequate exam or something, when they send it back to the regional office, you're back in the supplemental claim lane, essentially. So the record opens back up and you can submit whatever evidence you have then too. So is Andrews not ideal? Sure. Is it the end of the world? No, because we have all these options under AMA now, including, and if you have the evidence while you're at court, if all of a sudden you come across the smoking gun evidence while you're at court working out this JMR with the secretary, guess what? Under MVA, you can file a supplemental claim then with your new evidence and start marching your way towards that favorable decision for your veteran sooner than you possibly could under legacy. Another case that just recently came out, this was a case from my firm, Chisholm and Kilpatrick, has to do a lot with the forms regime, as my colleague April would say, is a term that I love, under AMA. Everything is on forms. Like if you don't use VA's preferred form, they will kick you out. If you don't check a box on your higher level review claim or higher level review request form indicating that you're opting in from the legacy system, they will tell you you can't get into AMA because you didn't check a box. I mean, they are serious about these forms. And it's supposed to help veterans to, well, what VA's position would be, this is how we're able to streamline the claims processing system, and our adjudicators don't have to spend so much time digging through the file, trying to figure out exactly what the veteran wants. It's all here in the four corners of the form. And that sounds really good, ideally, but the truth of the matter is the forms are often used as a sword against veterans as well. And so Hall was a case like that, where in 2015, so this was actually a legacy appeal, but even in legacy in 2015, VA issued regulations requiring that all notices of disagreements be submitted on specific forms. That requirement has now been codified into legislation via the AMA. So in January 2019, like I believe it was the day before AMA went into effect, if I'm not mistaken, the RO issued its initial decision on the veteran's claim in the legacy system and tells him to file an NOD on the legacy appeal specific form. But at the same time, the next day they go live with AMA and they've got a new NOD form that applies to AMA, and they publish it on their website and everything, right? So now there's no more legacy NOD forms, because any rating decision issued the day after Mr. Hall's rating decision is all in AMA now. So they don't even have an NOD form for legacy anymore. So okay, so February 2019, the same day that AMA goes into effect, he submits his notice of disagreement on the AMA form, because now it's live on the website, right? So he probably just went to the website, pulled it down, submitted it. And so 2 months later, the board says, all right, Mr. Hall, we got your NOD. It's on our docket. You'll get a decision, within X amount of time. There's nothing more you need to do. Just chill out and we'll give you a decision. So then 7 months after that, the board issues a decision dismissing the appeal for lack of jurisdiction, they say, because Mr. Hall, you submitted the wrong form. Your case was an AMA case. I'm sorry, your case was a legacy case. So you should have submitted the legacy NOD form, but you submitted the AMA NOD form, and your case wasn't an AMA case because it was issued a month before AMA went into effect. So sorry, we can't even look at your case. We don't have jurisdiction to look at it. And the Veterans Court said no. The NOD form is a claim processing rule. It's an important claims processing rule because it is really VA's way of making sure that they can get through these claims in an efficient manner without having to have adjudicators dig through files, having to look for, form pieces of paper where the veteran write something that they have to then liberally construe as a notice of disagreement. But it's not a jurisdictional rule. And there's a really important difference, because a claims processing rule means it's something that is important and we can enforce, but we can also waive it. But a jurisdictional rule cannot be waived. That is how the board gets its power to even review a VA decision. In that case, we had also argued that the board had waived the claims processing rule by accepting the AMA NOG. The court did not reach that issue and sent it back to the board to reconsider its reasons for dismissing the appeal, because it found that its determination that it had to dismiss it because of the jurisdictional defect was incorrect. So the reason why this is important for AMA is because, as I touched on before, there are a lot of forms in AMA. Everything in AMA is done on forms. And Hall says that the forms requirement are just claims processing rules. They can be waived, forfeited, and the time period for submitting them can be equitably told, which is another important thing that you cannot get with jurisdictional rules. And in my experience, and Amy, I would assume yours too, the adjudicators, because they've been trained to just look at these forms, they don't look outside the four corners of the forms at all. So it's only what's on the form that's going to dictate what the adjudicator does. And this becomes a problem in AMA, especially in notices of disagreement, where the form says, check direct review if you don't have any additional evidence to submit, right? And I've seen cases where the claimant will check direct review, but attach to the NOD material evidence that they want the board to consider, right? So clearly they either misread that as meaning you don't have evidence more than what's attached to this form, or they didn't understand like what exactly that meant. And they really want you to consider this evidence. And the board will say, nope, can't look at it because you checked a box that said direct. I think Hall is going to be really the first tiny little leak in the dam of cases that says, you can't do that. Like you have to, you can't just put your blinders on because we're in AMA and forms are king. You have to be able to look at the full context of the circumstances to determine what the claimant's intent really was. Now we've got a few on the horizon, two really big ones. I'm just going to quickly talk about Aviles Rivera. This was recently argued. This is a case, again, that has to deal with the board's, the record before the board. And so in that case, we have a Vietnam veteran who is legally presumed to have been exposed to herbicides as a result of his service in Vietnam, and herbicides includes Agent Orange. And he now suffers from hypertension. So he filed a claim in 2013 in the legacy system for hypertension. 3 years later, the National Academy of Sciences, by direction of the Agent Orange Act, says it goes and studies to see whether there is a relationship between or an association between herbicides and hypertension, and says there's limited or suggestive evidence. VA receives that report as required by statute. So they have it in their possession. Then the following year, the board remands the claim for a VA opinion that considers the 2016 report. And in 2017, the examiner says, no, this guy's hypertension is unrelated to herbicide exposure, even considering the NAS's conclusion, which was just that there was limited or suggestive evidence of a relationship. So now it's 2018, and veteran, it says he opts his legacy appeal into AMA. I'm assuming that was actually RAMP, which was like the AMA pilot program. So you could opt into the AMA system before it actually went live through VA's pilot program. But in either case, he gets his legacy appeal into AMA. Now the rules have changed, right? Now there's a limitation on the record on the evidentiary window has closed and the duty to assist does not apply. He's an AMA, doesn't apply to the board. Well, wouldn't you know, later that year, NAS determines that there is now sufficient evidence of an association between hypertension and herbicide exposure. To use that report, they have it in their possession. The following year, the board denies the claim based on the 2017 opinion, makes no mention of the November 2018 NAS report. Here's the problem. In this case, Eusebio, out of the Federal Circuit, they said that documents over which the secretary has control, including the NAS studies here, and are dated prior to the board decision, are constructively before the board. And that includes these NAS updates. The problem with that, Eusebio is a legacy case. It didn't address, what's constructively before the board when the evidentiary window is closed. So the issue in the case was the 2018 update constructively before the board, even though it came in after the evidentiary window closed? There are a couple of approaches that the appellant took. One is that it wasn't really evidence, but information, which is also identified in the statute as what the board must consider. And then there was an argument that Eusebio controls even in AMA. We don't have a decision on that case yet. I don't expect one for a while, but it's one to look for. Amy, what is your prediction here?
Well, I actually, I think we are just about out of time. So,
no.
But I watched the oral argument and I thought it was interesting because, of course, I'm drawing similarities between this case and the next case that we're not going to discuss because we're out of time, the Reitinger case. But the secretary at the oral, in the brief and at the oral argument basically said, no harm, no foul. The veteran can file can file a supplemental claim. And so the VA seems to use the ability to file a supplemental claim as a shield to sort of allow it to not consider evidence that was constructively in the record. And in the Reitinger case, the secretary is using the same sort of argument, saying that I could have filed a supplemental claim. And the Reitinger case had to do with VA not considering, the board not considering 3.156C in an AMA appeal when the veteran checked the direct review docket. And after receiving the notice of disagreement with direct review checked, then the veteran submitted relevant DEC logs, relevant service records, and the board, like Amy was saying, put the blinders on, and they really love the ability to close the record. That's a really important aspect of the AMA, and the secretary is really sort of hanging on that and basically protecting the board's ability to close the record over the veteran's ability to get a timely and fair adjudication of his appeal. I think in both cases, Judge Toth at the Aviles Rivera oral argument asked about Andrews and was specifically asking how that applied. And so I'm curious to see how this one comes out. Because I think they might draw a distinction with and sort of limit Eusebio just to legacy. I'm hoping that they don't, but given the how forceful VA uses 38 USC 7113 to close the record, it'll be interesting to see how this one comes out. We've got, and I guess we're going to make available to you the slides for that show the Reitinger case. And like I said, that was an issue with the operation of 3.156C in a legacy appeal where a veteran checks the direct review box. And that's oral argument is now set for December 8th. Say a prayer for me. And do we have any questions?
No. We're going to do questions and answers via email, if that's okay to stay on track, because we have such a wonderful program today. I wish you both were here, and we will definitely see you next year. Now it's my pleasure to introduce Gunnar Johansson, one of our students, who will introduce Mel. And Amy, thank you, thank you, thank you. Thank you.
Thank you.
We'll be emailing you questions from the chat and from the audience. Thank you.
Great, thank you.
Good morning. Thank you, Dean Trachtenberg. My name is Gunnar Johansson, and I'm a third-year law student here at Mizzou. I'm also a current student in the Veterans Clinic, and I'm loving it so far. I was really excited to do it when I came to Mizzou Law. Nearly every male member of my family has served, including my little brother, who's about to deploy to Qatar in about 3 weeks. So it was very important to me to give back and to be able to help them someday. But I also want to do this as a pro bono practice, too, when I graduate. So this morning, I have the privilege of introducing Miss Mel Bostwick. Mel is a partner at Orrick, Harrington, and Sutcliffe, and a member of the firm's Supreme Court and Appellate practice in Washington, D.C. Her practice focuses on high-stakes appeals with a particular emphasis on patent appeals before the Federal Circuit. She also has the privilege of representing pro bono clients and is particularly passionate about using her Federal Circuit experience to help veterans on their appeals to the Federal Circuit. In the landmark case Procopio v. Wilkie, she successfully argued before the Federal Circuit on behalf of Blue Water Navy veterans. The Mizzou Law Veterans Clinic actually filed an amicus brief in that case and worked with Mel's team to make sure all the arguments were briefed beforehand. I do want to read an excerpt of her oral argument here. It is quite astounding. Here is what Congress in 1991 knew. It knew that there was a growing evidence of an association between exposure to Agent Orange and several diseases. It knew that one of these diseases was non-Hodgkin's lymphoma. And it knew that non-Hodgkin's lymphoma affected Blue Water Navy veterans more than other Vietnam veterans. And I talked with her right before this, and she said it was the quietest the appellate court had been. And it was a long time before they actually interrupted her, which if you have done appellate law, that's quite astounding. After that argument, her team secured a 9-2 ruling that Agent Orange Act unambiguously granted Blue Water veterans a presumption of exposure and service connection based on having served in the Republic of Vietnam, even if they were stationed offshore. So before, you had to have boots on the ground to be service connected to Agent Orange exposure. This affected almost 52,000 veterans nationwide, allowing them compensation for being on the ships that used that recycled water that had been contaminated with Agent Orange. Prior to joining Orrick, Mel was an associate at a boutique litigation firm in DC where she represented clients in trial and appellate litigation and before the FCC. She got her BA at Northwestern and her JD at Harvard. She served as a law clerk to Judge Timothy Dyke of the U.S. Court of Appeals for the Federal Circuit and to Judge Thomas Griffith of the U.S. Court of Appeals for the D.C. Circuit. We thank her for support of veterans nationwide and for being here today, and we're very excited to hear from her. So please give a warm welcome to Mel Bostwick.
Much, Gunnar, for that introduction, and thank you to everyone involved with the clinic for inviting me here to speak today. It's a true honor. I've had the privilege, as Gunnar mentioned, of working with the Mizzou Clinic folks, as well as those at other veterans law clinics around the country for the last 3 years, and I have been consistently impressed by the energy and excellence that all of you bring to this critical work of advocating for our nation's heroes. I'm also just a tiny bit jealous. When I was in law school, Harvard had not yet established its veterans legal clinic, so I didn't get the benefit of that experience as a student. At the same time, I'm not sure I would have pursued the opportunity if it had existed. It wasn't until the year after I graduated law school, when I was clerking on the federal circuit, that I started to understand just how much of a need there is for veterans advocates and how much of a difference a lawyer can make for the millions of people who put their lives and livelihoods on the line for the benefit of our country and who ask only for fair treatment in return. I saw just a sliver of their experience in the appeals that would come before my judge. I will never forget the 2 veterans appeals I worked on in my first month on the court. Both of these men had suffered lasting injuries from their time in war, and both seemed to have been denied the full benefits that they should have gotten under the statutes that Congress had passed. But for reasons that had largely to do with the intricate procedural requirements that apply to VA claims, they hadn't gotten everything they deserved, and the court didn't have the power to give it to them. For a fresh-faced law clerk with a keen sense of justice, this was very discouraging. But on the other hand, throughout my year on the court, I also got to see a more hopeful side of the system. I saw advocates like Ken Carpenter and Bart Stichman arguing before the court, and I saw what a difference that advocacy made in their clients' cases. So I'm delighted to be here to, nope, wrong one. So I'm delighted to be here today to speak with you about how we can follow in their footsteps and work through the appellate courts to advocate for meaningful and lasting change for the veteran community. So to start, why is this such a big problem? Why do we need to get all the way up to the United States Court of Appeals to get things right, when we have some pretty good statutes on the books and a system that is meant to be non-adversarial and pro-veteran? There are some cynical answers to that question. You don't need me to fill them in for you. But I think there are other factors at play too. The VA benefit system has to process hundreds of thousands of claims each year. Those claims often involve finding and analyzing records that may be decades old, reviewing filings by people who may or may not be familiar with the law that applies to their claims, and coordinating medical and factual investigations with a legal analysis. That is a fair amount of work. And it's done in the first instance by people, the frontline adjudicators, who by and large have no formal legal training. We've all seen how the language of statutes and regulations can flummox even Supreme Court justices. This is often complicated stuff, and it's understandable that it creates errors. Of course, most veterans don't have legal training either, and there are not enough VSOs and pro bono attorneys to represent them all at the claim stage, where they are not allowed to secure paid representation, even if they know to seek out help and even if they're successful in finding it. And that's where most claims end. Although 43% of all claims are denied, only 16% of claims are appealed. And a lot of bad rules get entrenched that way. Even on appeal from an initial decision, when paid representation is allowed, less than 15% of veterans have a lawyer assisting them, and about 10% have no representation at all. So you have a big complex system trying to apply complex laws to complex facts, and not enough folks who are trained to help veterans navigate that system and preserve their rights. That's a system that's bound to produce errors, and it does. Just of the cases that make it up to the Court of Appeals for Veterans Claims, there is a finding of agency error more than 90% of the time. It is huge. It is more than any other agency that I've seen. It's also not always easy to fix those errors, at least not without some intentional strategy. So this is an overview of the process for reviewing veterans benefits claims, and this will sound familiar to those of you who saw Amy and Amy's presentation before me. As I said, you start at the regional office level, whether you're filing an original claim, one of those supplemental claims with new evidence, or a request for higher level review. You get a decision, you can appeal it up to the Board of Veterans Appeals. Here you've now got about 100 experienced attorneys who are serving as the judges and supporting staff members, including staff attorneys. You've also got plenary review. The board can look at the law, they can look at the facts, and they can make judgments about both. And they're the last people who can do that. So you have to get your best facts and your best arguments about those facts out at this level. If you get a bad ruling out of the board, then you can move out of the agency level into the court system. And that's actually only been true for a little over 3 decades. Veterans and their advocates fought for a long time to get judicial review of VA's decision, and it wasn't until 1988 that Congress came through with the Veterans Judicial Review Act. So the first court you get to is the U.S. Court of Appeals for Veterans Claims. They get to review the board's legal rulings. They get to review the board's compliance with all the procedural requirements that govern an agency's decision-making. They get to decide constitutional challenges, and they have a very narrow type of review over factual findings for clear error. But that's a heavily deferential standard. This court cannot fix all errors, which is why that board level is so critical for anything that implicates the facts. That only gets more true as you keep going up the chain. The Federal Circuit is the first Article III court that reviews a veteran's case. It has an even narrower standard of review. They can look at the law, they can look at the procedure, they can look at constitutional questions, at least if the veteran has preserved those arguments in the court below, but they can't review facts or even how the law applies to the facts. Their hands are tied. The Supreme Court, which reviews the Federal Circuit, has the same limitations, and that's if you even get them to look at your case. Somewhere around 3% of all petitions for certiorari to the Supreme Court are granted, so it's quite a long shot. And the takeaway here, I think, is twofold. One, with the limitations at the tribunals that are best equipped to resolve complex legal questions, you can see why so much bad law gets made and why it persists. And two, if you want to challenge one of those entrenched rulings, the best way to do it is by having an advocate who can help the veteran set up that challenge at the agency level where the scope of review is the most generous and any factual issues can get clarified. But that's not always possible. Sometimes you find yourself diving in on a Federal Circuit appeal and you've got to take the record as you find it. However you end up there, the first rule is always the same. Know your audience. These are the 19 judges of the Federal Circuit, 12 active, 7 senior. I often use a version of this slide with my patent clients to underscore that the judges, even on this expert patent court, don't necessarily have any expertise in the technology involved in their case. But I think a similar message is important for veterans advocates to appreciate. Of course, these judges, they see all the veterans' appeals that come to their court, they know the law very well, and they study each issue extremely carefully. But most of them have no firsthand experience trying to navigate the VA system, let alone an understanding of what disabled veterans experience. Just 3 of these judges have served in the military, and all of those 3 are on senior status since Judge Wallach went senior earlier this year. He and Judge Mayer and Judge Plager are all hearing and deciding cases, but they don't hear nearly as many as the judges in active service. And with rare exceptions, they don't sit on the en banc court that decides some of the most important veterans cases. Judge Hughes has experience from the other side. Before he became a judge, he ran the DOJ Commercial Litigation Branch, which advocates on behalf of the VA in Federal Circuit appeals. So he also has a deep understanding of the VA system. And as a judge, rather than an advocate, he can take an objective view of that system. So the cardinal rule of appellate lawyering applies with special force here. Don't assume knowledge on the part of your audience. Even if something is self-evident to you, something about the process, something about a veteran's experience, you have to explain it clearly and carefully to the judge and the law clerk who will be reading your brief. So I want to talk about a few different ways you can find yourself before the Federal Circuit and what kinds of things you can accomplish there. The first is not the most common, but it is a great way to preemptively fix a lot of the problems that the VA creates. And that's by challenging the regulations that VA adopts when it adopts them. Like basically every federal agency, sometimes the VA's regulations are not exactly consistent with the statutes that they're supposed to be implementing. And there's a statute that allows you to seek judicial review of those rules when they're promulgated, without waiting for the rule to be enforced against you in an individual case. If you do this, you can solve a lot of problems without making thousands of veterans go through that system we talked about, having an unlawful regulation applied to them, and maybe never even having a chance to challenge that bad decision. One recent example of this is the case that Amy and Amy talked about, military veterans advocacy versus Secretary of Veterans Affairs. As they explained, several veterans organizations challenged those rules at the Federal Circuit. I was delighted to be part of that challenge on behalf of military veterans advocacy. I'm even more delighted that MVA entrusted my associate, Robbie Manass, with arguing the appeal and helping him build his courtroom experience early in his career. And Robbie did great. As you can see, the veterans organizations collectively were able to get 3 of the VA's rules knocked out. Veterans are going to get a fairer adjudication process from the get-go because everyone pursuing claims will benefit from this ruling, without each of them having to challenge an unlawful rule one by one. A few things to keep in mind if you're bringing one of these preemptive or pre-enforcement challenges. First up, make sure you're challenging something that you can challenge under the statute, which is Section 502 here. Congress did not make this one easy for us. The words of the statute say that it applies to an action of the Secretary to which Section 552A1 or 553 of Title V or both refers. And those 2 sections in turn have a bunch of their own requirements. So it's a little confusing. Everyone agrees that a regulation codified in Title 38 of the CFR counts, but the VA makes a lot of rules that aren't codified so formally. A lot of them, in fact, are in the VA's M21 adjudication manual. And last year in the Nova case, in which a lot of us participated, including as amici, the Federal Circuit overruled its prior precedent and held that the manual provisions are subject to challenge under this statute if they essentially function like regulations, which is they're substantive rules that are generally applicable to parties before the agency. That same Nova decision also clarified another issue that was the source of longstanding confusion. When do you have to bring your challenge? The statute itself, Section 502, does not set a time limit, and the default rule for civil suits against the government is 6 years. But the Federal Circuit for a long time had a local rule on the books that set a 60-day time limit for Section 502 actions. You have to bring it within 60 days after VA creates the rule you want to challenge. The en banc court, happily, has now acknowledged that rule was unlawful and that the statutory period of 6 years governs. And that's great, because we might not even learn about a bad rule within 60 days of it being issued, especially if it's adopted in the manual rather than codified in a formal regulation, let alone have time to mount a campaign among veterans advocates to challenge it. That extra time is even more important post-Nova because while the court giveth, it also taketh. Being an Article III court, the Federal Circuit requires litigants to have Article III standing to bring a claim, and that includes a Section 502 action. The Supreme Court has long had some pretty intense standing jurisprudence, but for quite some time at the Federal Circuit, this requirement was not stringently enforced. And if you were a veterans organization with veteran members, you could bring one of these 502 cases. The Nova case changed that. You now have to show a more direct link between the rule being challenged and the specific members of your organization or you as an individual. And you have to do it at the outset of your appeal. Typically, you do this by attaching affidavits to your opening brief, showing how particular members are affected. Do I need to talk louder? And this is a jurisdictional requirement. So again, it's not a claims processing rule, this is jurisdictional. So it's very important to get it right or you'll lose your ability to bring the challenge. And finally, don't lose sight of the fact that your challenge can be broader than just saying that the rule is inconsistent with the statute. The APA's standard of review here applies as it does to any other agency, and that includes challenging whether the VA's decision-making process was arbitrary and capricious, for example, whether it complied with the requirements regarding notice and explanation of the agency's reasoning and all of those restrictions. So you want to look and see if those are the kind of arguments you can raise as well. Okay, so let's say you're stuck with a bad rule that did not get fixed through a 502 petition, or you've got a problem that doesn't involve a VA regulation at all. Didn't I say there's that really narrow standard of review? Can you really do much at the Federal Circuit in an individual benefits appeal? Yes, if you're adequately prepared. And that includes knowing that narrow standard of review and how to work with it. Remember, you've got to show the court that the decision below turns on an issue of law, not a question about how the VA resolved the facts, and not a question about whether the VA applied the law correctly to those facts. Did it get the law right in the first place? No matter how carefully you do this, you're going to see the same thing from the VA. This court does not have jurisdiction. It's the first argument in pretty much every response brief that the VA files, so expect it, lay the groundwork in your opening brief, and be prepared to defend it. And remember, if you're dealing with a constitutional issue, the court's scope of review gets a little bit broader. Here, the court can look at how the agency applied the law to the facts. It still can't resolve factual disputes, but what it can do is look at the application of law to fact to make sure that that was consistent with the Constitution. This is an issue in one of the upcoming en banc cases, Taylor, where one of the questions is whether the VA violated the veteran's constitutional right of access to the claim system with the way it enforced the effective date statute that applies to benefits. In this case, nobody's disputing what the statute says, so there's not a disagreement over what the law is. The question is, can it be applied to the facts of this veteran's case consistent with the Constitution? And the court is able to look at that application of law to fact. Now, I've mentioned preservation a couple times. It's key. It's right here in the statute. The Federal Circuit can only look at an issue that was part of the CAVC's underlying decision. That means the veteran had to raise it at the CAVC. You can't expect to make a new argument on appeal. And if you're coming into a case new at the Federal Circuit level, you've got to figure out how to work within that restriction. You also have to show that the error you're alleging actually mattered. Even if you're totally right about the law, you're totally right that the VA messed it up, if the veteran would have lost anyway for some other reason, it's harmless error and you're out of luck. Finally, a word about that APA standard, which appears in pretty much the same language in the Federal Circuit's review statute as it does in Title V. So this bottom block here, those are a lot of lawyer words. Don't let them trip you up. Figure out what the heart of your challenge is. And don't just say something's arbitrary and capricious just because it's wrong. A lot of things are unlawful without being arbitrary. You'll waste space in your brief, and you'll burn credibility if you try to make your challenge fit into every one of these boxes. Also, don't underestimate the impact that even an individual appeal can have. We talked about pre-enforcement rule challenges earlier and how it fixes the law for everyone all at once. It's still possible to have that same level of impact even when you're only directly representing one veteran. In addition, of course, to the significant impact you'll have on your individual client's life. An example of this is a case that I worked on with MVLSP a few years back, involving the familiar tripartite test for service connection. Tripartite is a word I love to say. I suspect most of you are familiar with this, but to get disability benefits, you have to show the veteran has a disability resulting from personal injury suffered or disease contracted in the line of duty. That middle box is what we call the nexus requirement. The third box is often called the incurrence requirement. But what about that first requirement, a disability? What do you have to show? Well, for a long time, the VA said that you can't just show that you're in pain. Even if that pain is literally disabling you from earning a living or going about your life, they said it has to be pain that's associated with a currently diagnosed disease or injury. That's not what the statute says. It talks about an in-service disease or injury, but the only thing you have to show at present is that you have a disability that's linked to that prior disease or injury. So this is a great success story of an organization here, NVLSP, working hard to look for the right case to bring this challenge up to the Federal Circuit, to make sure that they made all the right arguments at the Court of Appeals for Veterans Claims, and to give the Federal Circuit something that they could use to fix the law. And it worked. And I was very fortunate to be able to work with them to bring this appeal, where the Federal Circuit easily recognized that the VA's approach was at odds with the statute. Disability means functional impairment. Functional impairment includes pain. That decision was a great relief to our client, Ms. Saunders, and it's been cited in more than 13,000 board decisions in just the 3.5 years since it issued. Don't underestimate the impact of individual appeals. That's especially true if you've got an issue where it's Federal Circuit law that you're trying to fix. The Federal Circuit is not immune from making mistakes, and there are a fair number of decisions, many of them older decisions from a time when there weren't as many veterans who had legal representation at the court, that are continuing to cause problems for veterans. An ordinary 3-judge panel can't fix them because they can't overturn precedent. You need the court to sit en banc, which means all of the active judges, those 12 folks on the slide we saw earlier. This is not a common occurrence. Some appellate courts go en banc fairly regularly, but the Federal Circuit hears at most 1 or 2 en banc cases each year. The good news is that lately, they've been using that rare procedure more and more to tackle important issues in veterans law. In the entire time the court has existed, since 1982, there have been 130 en banc decisions. Just 10 of those were in veterans cases. But 5 of those 10 were in the last few years. And in the last few years, only one en banc case was not a veterans case. Why is the en banc court suddenly interested in veterans issues? Obviously, we don't know for sure. I suspect it has something to do with the fact that there aren't a lot of en banc opportunities in the patent space right now, and that's one of the other key areas of the court's jurisdiction. The court has either addressed the problems in patent law en banc, or it's realized it cannot sort them out. But veterans law is a place where they can come to agreement and make some progress, especially in rethinking older decisions. At least in some instances. These are the 5 recent en banc cases I mentioned. 3 of them had unanimity or near unanimity, which can allow the court to make real progress in shaping veterans' jurisprudence and providing clarity to veterans and their advocates. One is the Procopio case that Gunnar talked about in his introduction, where I had the honor of arguing before the en banc court and overturning a decade-old panel decision. That panel decision had held that the VA's boots on the ground rule was proper because it found the statute ambiguous in terms of whether service in the Republic of Vietnam encompassed service in the Republic's territorial seas. Because it was ambiguous under Chevron, the Federal Circuit said it had to defer to the agency. The en banc court took that, and in a 9-2 decision, they held no, the statute is unambiguous. A country unquestionably includes the territorial seas that are part of that country, and the VA's rule was invalid. That decision also led to legislative action and to thousands of veterans actually receiving benefits that they had long been denied. I continue to hear from veterans who are suddenly getting their claims granted that they had fought so long. And so it's really great to see just that the real direct impact that a court case, even up at in the obscure appellate area, can have on people's lives. Another one is the Nova case, which I mentioned, where the court significantly and unanimously improved the process for pre-enforcement review challenges. And the third is the Francois case from 2019, where the court used its en banc footnote process to overrule prior precedent. So this is a case goes to an ordinary 3-judge panel. That 3-judge panel decides it, but if there's one issue that they're deciding where they have to overturn prior precedent, they go around to all the judges on the court and get them to sign off on a footnote that says, yep, I agree with that. So there's this just that footnote is an en banc decision. Here they used it to overrule prior precedent regarding the presumption of competency for VA medical examiners. The problem is that the court didn't actually make clear what was changing. They said, there's no presumption of competency, it's now a requirement. And they said, anything we said previously in these couple of cases is overruled to the extent it's inconsistent with what we're saying today. I don't know what that means. We don't get that beneficial clarity that we get from the Procopio and Nova decisions. That same lack of clarity plagued the most recent en banc ruling out of the court in the starkest way possible, an evenly divided court, 6 judges on one side, 6 judges on the other, and that results in upholding the decision below from the Veterans Court. That's the Arellano case. This involved the availability of equitable tolling for the statute governing effective dates for claims. So remember, typically when you file a claim for benefits, your effective date of any benefits that are ultimately granted is the date you filed that claim. But there's also a statute that says if you file your claim within 1 year of discharge from active service, then the benefits are retroactive to the date of discharge from service. Question in the Arellano case is, okay, what if the very disability that you're trying to get benefits for prevents you from filing within that 1 year period? Does the court have the equitable power to say we're going to toll that statute, and even though you didn't file within the 1 year, we're going to give you that earlier effective date as of the discharge from service? Currently, the answer is no, because the Veterans Court said it was no, and the Federal Circuit could not come to agreement. There is a cert petition pending in the Supreme Court. I filed an amicus brief in that one as well on behalf of MVA, and we're waiting for the government to respond. So hopefully the Supreme Court will take that one up and give us some clarity on equitable tolling. We're also waiting to see what the Federal Circuit does in Taylor, where the en banc briefing is underway. This case also implicates the equitable tolling issue, but the Federal Circuit said, yeah, no, we couldn't figure that out, so don't talk to us about that anymore. Instead, they'll be addressing the related doctrine of equitable estoppel. This also applies to that 1 year effective date statute. Here, the veteran, Mr. Taylor, was subjected to toxic chemical exposure by the military as part of the Edgewood Arsenal human experiments. He was forced to sign a secrecy oath that he could not disclose that he had participated in those experiments, and that included preventing him from filing a claim with the VA to get benefits for the disabilities that resulted from the horrific things he endured. So the court will be determining, is the VA equitably stopped from saying, well, you didn't file within the 1 year. Obviously, he couldn't file within the 1 year. He couldn't file until he couldn't file until about 35 years later, when the DoD finally said, okay, we're cutting back on your secrecy oath just enough to let you file a claim. Is the government stopped from denying him full retroactive benefits? A panel of the Federal Circuit had said yes, Mr. Taylor, you get 35 years of back benefits. A few weeks later, the en banc court, out of nowhere, sua sponte, said, no, we want to rethink this. Now, they issued an en banc order that gives some optimism that they're trying to do the right thing. They're going to take up as I said, they said they don't want to hear about equitable tolling anymore, but they're going to take up the equitable estoppel issue. They're also going to look at this constitutional issue that I mentioned earlier, which is, did the government's oath of secrecy requirement interfere with Mr. Taylor's constitutional right of access to the VA benefit system and the courts? So not great, certainly not great for Mr. Taylor that they took that away from him, but I think there is reason to be optimistic about what the ultimate outcome there will be. Of course, if they don't get it right, there is always the Supreme Court. As the statistics I mentioned earlier show, this is a long shot, but the Supreme Court has taken many veterans' cases in the past, and there's every reason to think it will do so again. There are a number of issues that I think are ripe for their review, most obviously the 6-6 Arellano decision, where, as I said, there's the petition filed recently. We have the Kaiser case that Amy and Amy talked about. I'm particularly partial to this issue in a cert petition that my team and I filed over the summer, where we're asking the court to say that a Q claim is available when the VA denies a claim based on a reading of the statute that a court later says is unambiguously wrong. So here, there was the statute had said the same thing all along. Our client filed his claim in the 70s. There was a VA regulation that didn't go as far as the statute. So they denied his claim based on the regulation, but if they had applied the statute, they should have granted it. He loses. Decades later, the Federal Circuit says, oh, no, this regulation is not valid. This statute unambiguously requires X, the regulation says Y, no good. So when a court says what a statute unambiguously means, that's what the statute has always meant. So we think that qualifies to say that the original decision was a clear and unmistakable error of law, and not, as the Federal Circuit held, a mere change in interpretation of the law. We'll see what the Supreme Court does with that. We are also awaiting the government's response in this case. When you're crafting a cert petition like this, there are a number of strategies to keep in mind. I'll touch on a few key points. First, as you can tell from the cover page, you have to have an absurd number of lawyers on your team. No, but this other excerpt is important. The question presented. It's the first thing the law clerk will read when they pick up your petition, and you've got to persuade them that it's worth their time. These are extremely busy folks. It is so much easier to write a cert pool memo that says you should deny this case, when most cases are denied, than it is to recommend a grant. So you have to capture their attention and convince them you're worth it. And to do that, you've got to drill down carefully on what exactly you want the court to decide. The Supreme Court does not care about an error in one case, no matter how unjust. You have to frame the issue to show them that it's an opportunity to provide necessary resolution of an important legal question that will have significant impact. I always write the QP last. I probably go through at least 20 different iterations of it and then edit the heck out of it with the team. It's just the importance cannot be overstated. You also want in the QP and elsewhere in your petition to tell the court why they should care. Notwithstanding outward appearances, Supreme Court justices are people too. And they want to understand not just the doctrinal effects of their actions, but the effects on, people. They also want to understand the effects on other areas of the law. So an issue we talk about a lot in veterans cases is the pro-veteran canon, this idea that statutes that benefit veterans have to be interpreted to effectuate Congress's presumed pro-veteran purpose. But you've got to be careful when you're talking about something like a canon of statutory interpretation, because the Supreme Court's going to be thinking about all of the other canons that are out there. What about, the rule of lenity in criminal cases? What about others? What is this decision in this case going to do in other areas of law that I maybe am not even anticipating? So you have to be prepared to answer that question, and you have to have that in mind from the outset. Another analogy you can draw in the veterans context is to the inter-circuit split. So among Supreme Court practitioners, this is known as basically the #1 way to get cert granted. The 8th Circuit says this law means one thing, the 1st Circuit says it means the opposite, we've got to have the Supreme Court resolve it. That doesn't happen in veterans cases because the Federal Circuit, one court, has exclusive jurisdiction over those appeals. It decides all the issues in the area. But you can still show internal dissension that can help prod the Supreme Court to intervene. Obviously, the 6-6 en banc split in Ariano is one way to do that. But even if you've got 1 or 2 dissenters, and especially if they've taken the time to pen a dissenting opinion, you can capitalize on that to justify your request for cert. How else do you justify your case for cert? By showing that everybody cares about your issue. Having support in the form of an amicus curiae briefs is crucial. It shows the court that it's not just you, the petitioner, who's saying that this issue is important. It's all these other stakeholders who will be affected by the decision. Amicus briefs aren't just important at the cert stage, though. You only get limited space in your brief to address all of the complicated issues in a case. And sometimes there are side issues that are interesting and helpful, but not important enough to give full attention to in your main brief. So you can use your amici there to help inform the court about all aspects of the issue that's before them, the history, the policy, the human and economic impacts. And when all the big veterans groups sign on as amici, the court notices. These are the amici from one of the recent veterans cases where the Supreme Court granted cert. And it's not just at the Supreme Court. The en banc victory in Procopio, we could not have done that without the overwhelming amicus support we got from veterans groups across the country, including the law school clinics led by Professor Drake. That was a complicated case. It covered a lot of topics. I had to learn about the law of the sea. There was some really intricate legislative history. There were, in fact, issues about other canons of statutory interpretation and how the decision in that case might affect them. There was so much stuff, and we got 14,000 words to address it. So we worked carefully with our amici to ensure that the Federal Circuit got as much information as possible on every angle, and it mattered. It mattered to the decision. It is incredible to me to see this collection of briefs and this collection of advocates, and to see everyone here today or here virtually. I could not have imagined this back when I was a law student, law clerk. And I'm so delighted to be a part of this movement to fight for those who have fought for all of us. Thank you. Should we take questions?
Yes, thank you, Mel. We're going to take questions, and we're going to ask people to come to the mic, and you can form a queue. So if you could stand, sir, please, and ask your question. Thank you.
I don't really know what an en banc is. I was wondering like what that is and why do they like why does the Federal Circuit Court only take some cases en banc?
Because it's a lot of work. So normally when you file an appeal, your case gets assigned to a random panel of 3 of the judges on the court. But there's 19 judges total on the court, 12 of them active. And so, so you get 3 of those judges, they can decide your case. What happens is, if the court has an earlier decision that is precedential, it binds that panel. And so even if that 3-judge panel thinks, you know what, we don't agree with that earlier decision, we think they got the law wrong, they can't say that. They don't have the power to do it. What they have to do is get the en banc court, the full court together, to rehear the case, because only that full 12-judge court has the authority to overturn a prior decision. So basically, if there's bad law that's been made at the panel stage, the only way to change is getting the court to go en banc. And the reason that it's rare is there's a few reasons, not just that it's a lot of work. One is there's the idea of stare decisis. There's an idea in our legal system that we want predictability, we want continuity, we don't want the law to continuously be changing. It's really hard for people to figure out how to navigate that system if there's no predictability. And so you don't want it to be always the case that a court is saying, no, we got to fix that, no, we disagree. You especially don't want that to happen as a function of the membership of the court changing, because that just undermines sort of faith in our legal system. But it also it is an extraordinary amount of work. There's a new round of briefing typically in these cases. As you can see from the Procopio slide, there's often a lot of amicus briefing. It's a lot for the judges to read. It's often some of the most complicated issues in the law that they're dealing with, and so it just adds on to an already pretty extreme workload.
The Supreme Court would work better if it was the same way.
I got a lot of ideas about how the Supreme Court could work better, but the interesting thing about the Supreme Court is every one of their decisions is en banc, right? You don't have a panel system, and so it's sort of like the ultimate en banc court in that way.
Yeah, but would it work better if they had panels?
No, I don't think so. I think with the Supreme Court, with the number of cases that they take being so few, it's really important that we get all 9 of their attention on each of those cases.
All right, thank you.
Thank you.
Hello.
Hi.
I'm wondering how it sounds like most of the work on the veterans law side is dealing with the regulations, not so much the statutory change. I'm wondering how quickly and how chaotically regulations are made and changed and added, so what kind of a timeline are we looking at for that kind of a thing?
Yeah, so it varies, but it's definitely more flexible than the statutory system, right? It is, particularly at this moment in time, really hard to get legislation passed through Congress. It's easier to get it passed through the agency, and the agency can kind of go into more detail on particular issues, right? The statutes tend to be pretty high level, and then the regulations kind of fill in the gaps. It's not a super quick process because under the APA, the agency has to, if it wants to adopt one of these rules, it has to give people notice, it has to take comment, it has to consider them, and then it has to write an explanation of why it's coming to the decision it is. It has to publish that in the Federal Register. There are ways to kind of fast track that process, but I would say typically, getting regulations done is something that could be done on the order of a year, which doesn't sound very fast. They can do it faster if they have to. Often there's ways to, for example, if there's a new statute, there's often kind of an interim rule that gets put in place while they figure out what the permanent rule is going to be. So it varies, but definitely faster and easier than legislation.
It's a pretty ever-changing landscape, then it sounds like, that you're working with.
Yeah.
Thank you.
Thanks.
Good morning. Thank
Good
you for
morning.
coming in. Obviously, Taylor and Ariano are very exciting for veterans law. Do you see any other cases pending or rolling down the chute soon that you're fingers crossed on, or have good opportunities for us?
At the federal circuit level?
Yes, ma'am.
Yeah. Well, I was paying close attention to Amy and Amy's presentation, looking at those decisions that are bubbling up through the CAVC. I guess the Hall case will not be an opportunity because the court got it right, so that's fantastic. I think. There none that stand out in a way that I think, oh, this is going to be an en banc. At least not, or the briefing isn't already done. But the thing to do if you want to get involved, if you want to, to work on an amicus brief, is to watch, just watch the court, watch what it's doing. The opinions that they issue come out every day at 11 Eastern, 10 Central. And that will include en banc orders, like in the Taylor case. And as soon as one of those comes out, people are going to be scrambling to do amicus briefs. But also just staying in touch and being in a clinic, great way, because your clinic instructors are certainly going to know about these opportunities. Kind of tracking what the big veterans advocacy groups are doing, what issues they're focused on. So just kind of being aware of what's going on in the space is kind of the most reliable way.
Yeah, I know Professor Drake and Professor Reeves pay very close attention to what's happening.
And if
Thank
they
you.
happen to miss one, I'll send them an email right quick asking for an
Great.
amicus brief. So,
Thank you.
yeah.
Hello.
Hi.
What is your favorite thing about being an appellate attorney?
I think what I like best is that my job is basically to tell my client's story, right? I'm a storyteller. And I get, unlike trial litigation where you're sort of constantly dealing with deadlines and having to juggle all manner of things, I get to really focus, really pay attention to the brief that I'm writing, the argument I'm preparing, and think about how best to get this court to understand why my client is so right? And how this case came to be and what effects it has. It's a lot of fun. It's you can make a difference. You can make progress in the law, and that's great. But the day-to-day work itself is also just so much fun.
Thank you.
Thanks.
All right, thank you.
Great.
Thanks, Mel. We really appreciate Mel traveling here from DC and sharing her words of wisdom with us. Just a few quick announcements. At 11 o'clock, our keynote, Bart Stichman, will present. Lunch will be after Bart's presentation. If anybody has questions that were not answered, please feel free to email them to me, including from the first presentation. My email is drakea@missouri.edu. The program material, the PowerPoints, the cases that Mel has been involved with are all on our website. So you can look there for the program material, and we ask that everybody fill out their CLE evaluation form so that we can comply with the Missouri Bar. So thank you, and we'll see you at 11 o'clock for Bart Stichman.
Hello. Oh, that's really loud. Hello, my name is Kara Luchtefeld, and I am a second-year student here at Mizzou Law, and I have had the opportunity to work in the Veterans Clinic this semester, which has been a great opportunity, and my family members have served before, so it's been awesome to be able to help veterans like my family members. I have the pleasure today to introduce our keynote speaker, Mr. Bart Stichman. Mr. Stichman went to New York University, where he received his JD, and then he went to Georgetown University, where he received his LLM. And ever since then, he has dedicated his legal services to helping veterans. He's actually raised over $5 billion in retroactive disability, death, and medical benefits for veterans. He also co-founded the National Veterans Legal Services Program, also known as NVLSP, as you probably heard today, and he did that in 1981. He also helped author our lovely Veterans Benefits Manual, and you've probably heard that referred to as the Holy Grail, and it helps any veterans advocate kind of navigate the process, and at the Veterans Clinic here at Mizzou, we love to use it. He served for 40 years as executive director of NVLSP, and he recently stepped down, but is still serving as special counsel to NVLSP, which just goes to show the dedication he has to helping veterans. And he recently received the National Legal Aid and Defender Association's Charles Dorsey Award, which honors an individual who has provided extraordinary and dedicated leadership to both the equal justice community and to organizations that promote access to justice for low-income people. Please help me in welcoming Mr. Stichman.
Good to see you all. It's a pleasure to be here. I want to thank very much Angela Drake and Julia Reeves for their great work and for the Missouri Clinic and all you clinical students for your work on behalf of veterans and their families. We need you all. Access to good counsel is a key, and it has been one of our missions at NVLSP since the outset. The theme here is pushing the envelope, and that's what I've been doing, NVLSP has been doing for its entire existence. But I think it's important to understand why is that important to push the envelope. And I've been involved, as they say, in this area of the law for 45 years, and my observation is that ever since the Vietnam War, the government hasn't kept its promise to veterans. And what I mean by that is it promises veterans, or those who serve in the military, that if you get hurt or become ill during service, we will take care of you. Your medical costs, the harm to your ability to earn a living in civilian society, all of that, the government will take care of so you're not harmed by your military service. And unfortunately, the government has not kept that promise since the Vietnam War. We did great for those who served in World War II and to a large degree the Korean War. But starting with the Vietnam War, large groups of veterans, that promise has not been kept, I'm sad to say. And the refusal to pay the costs of war, that's a bold statement, occur in two colors. First, I've noticed that the VA and the military departments often don't believe, when it comes to claims for benefits, what the veteran is stating occurred to them during service, and often their symptomatology after service, their lay statements. And the reason I believe they don't do that is because they know there's a possibility the veteran is lying, and they want to make sure that they're paying taxpayer money to veterans who really deserve the benefits. And the problem with that attitude, besides the fact that it violates the law, which says there's no requirement of corroboration of the veteran's lay statements. You can turn it down if you disbelieve the veteran and you can articulate good reasons why. But the reason why the problem with them rejecting the lay statements out of hand is that you're throwing out the benefit claims of the truth tellers as well as the liars. And so you're not giving the benefit of the doubt to the veterans, and you're not complying with the law that requires you to articulate a reason for the denial. The second aspect of the failure to pay the costs of war have to do with the military and the VA rules and practices that they have that violate the law. There's too many of them. They're wrongful obstacles that veterans must overcome, and that's why we, as you'll hear, use litigation, class actions, and lobbying Congress to get rid of those unfair or illegal obstacles. So, I'm going to take you through a tour of our history and how we have pushed the envelope. And as mentioned, I helped co-found with David Adelstone the National Veterans Legal Services Project and program in 1981. And it's a nonprofit organization based in Washington, D.C. It was created with funds from private foundations and an annual grant from the Legal Services Corporation so that we served as a national support center for legal services offices around the nation. We've been pushing the envelope to break the circumscribed rights of veterans based on unfair laws and practices in three major ways. One, through class actions and other law reform litigation, lobbying Congress, and trying to expand the pool of effective advocates. Those are our three major ways that we engage in pushing the envelope. And we started out, even before NVLSP was formed, in focusing on discharge upgrading. And let me get out my watch to make sure I don't go over time here. The Vietnam War, a highly unpopular war, produced a lot of veterans who were issued less than honorable discharges, which prevented them from getting VA benefits, and it was a stigma on them in civilian society, making it a ticket to a lifetime of underemployment. There was a big drug problem in Vietnam. The soldiers, Marines were disillusioned with the war, as was the public, and the military responded by issuing these less than honorable discharges. No other employer in the United States grades your employment when you leave and gives you a certificate saying you're undesirable, as the military did during the Vietnam War, or your service was under other than honorable conditions. And so that's a stigmatizing impact on the veteran. The employers, when they're seeking employment, will ask to see your discharge certificate, and makes it very difficult for the veteran and civilian society. For example, during the Vietnam War, they needed bodies, and they started a program called Project 100,000, in which they lowered entry standards so that people they wouldn't have accepted because they were unqualified before, they let in. And then what happened when they got sent to Vietnam? their performance was unsatisfactory. Surprise, surprise, surprise. And then what did the military do? They discharged them with a less than honorable discharge, making them worse off than when they entered the military. And so we, David Addlestone started even before he hired me in representing veterans to get discharge upgrades. And I had a background in administrative law, so one of the things we did was file a lawsuit on behalf of a lot of veterans organizations that were advocates, nonprofits like the Urban Law Institute of Antioch College was the lead plaintiff, and the discharge review boards and boards for correction of military records, which are the discharge review agencies with authority to upgrade discharges, didn't write, for the most part, any statements of findings and reasons, didn't explain their decisions. A lot of them were either grant or denied, and that violated the law. It also violated the law that even when they wrote decisions, they didn't make them publicly available so people could see the circumstances in which they'll grant or deny benefits. So we filed this lawsuit under the Freedom of Information Act to get that, and the Administrative Procedure Act, to get those deficiencies corrected, and reached a settlement that required these boards to write decisions that responded to contentions and otherwise explained why they did what they did and make them publicly available. In addition, as you can see, we filed some class actions that resulted in upgrades and discharge for thousands of people who were denied, who were issued a less than honorable discharge, and the court ordered them upgraded. Then, as we're wont to do, we produced a manual in 1980, right before NVLSP was formed, with funding from Legal Services Corporation, to explain to advocates, and there weren't many, and we were trying to recruit them to represent veterans on discharge upgrade applications. We wrote a big manual for them, and some of the organizations. We published a supplement in 1990 of this, but then we've been too busy to produce another supplement, so I'm happy to say that a number of other organizations have banded together and produced a new discharge upgrade manual. So starting in the 80s, we changed our focus more from discharge upgrading to combating unfair practices of the VA. And that was made difficult by two very unfair laws that had existed for a long time. And you've heard Mel talk about the fact that since the Depression, Congress had barred veterans from appealing any benefits denial to a federal court. Veterans were truly second-class citizens. And in addition to that, a law that was enacted in 1862 during the Civil War prevented lawyers from charging over $10 as a fee to represent a veteran on a claim before the VA. That sounds astounding, but actually $10 was a fair price back in 1862 for a lawyer's help in what was then a very simple system. But Congress never changed the $10 limitation due to inflation, and so it became, in effect, an economic bar to lawyers representing veterans, so they were on their own. And so we worked throughout the 1980s, and it was a 10-year battle to get Congress to repeal that law. And we formed an alliance with Vietnam Veterans of America. Vietnam veterans were not treated well at the VA, even more so than veterans from other eras. The VA employees, most of them, a lot of them were veterans from an older generation. World War II or Korean War, and Vietnam veterans were the soldiers and Marines who lost the war. And so there was bad feelings towards them, and their claims didn't get granted as much as they thought they should be. And so they led the battle, and against them were two major forces. One, Sonny Montgomery, the chair of the House Veterans Affairs Committee, who never met a federal court that he liked, and the veteran service organizations, the big veteran service organizations, the American Legion, the Veterans of Foreign Wars, Disabled American Veterans, and they were against it, even though they had millions of members who would benefit from another bite at the apple. All the arguments for repeal were that give veterans the right to appeal after they lose at the Board of Veterans' Appeals to a federal court. The worst that can happen is they lose at the federal court. No harm, no foul. Can anybody here guess as to why these major veterans organizations with millions of members who might be benefited from that were against it? This is I know a lot of you, most of you go to law school, so you're probably used to somebody in my position asking you a question. Yes, sir.
I think there was one concern, this might not be the one you're looking for, but that introducing the adversarial court system to the pro-veteran, non-adversarial lower system would muddy the waters.
Yes, that's one of the reasons that the veterans, stated reasons, that the veteran service organizations gave in explaining to Congress why they opposed, that it would change an informal system to a formalized system. It's occurred a little bit since then, but there was another reason that they didn't talk about much, and that other reason was they provided non-lawyers to represent veterans for free at the agency level, and that's still true today. And they were worried that veterans wouldn't need their services anymore, going to lawyers, and it would wipe out their representation system, which was how they gathered members and made them powerful. They didn't really articulate it that way, although the DAV filed a Supreme Court brief against the challenge to the $10 fee limitation, saying exactly that. At any rate, the Senate each year would pass a bill, either 99 to 1 or 100 to 0, providing for judicial review either at a U.S. district court, or some bills would put it in the courts of appeals. Every time, Sonny Montgomery would make sure there was never a vote in his committee, at the House Veterans Affairs Committee, on legislation to repeal. We would bring horror cases in hearings that he was finally forced to hold in the mid-'80s, and he would say to us after the hearing, he says, "Why didn't you bring these cases to me? I could get it fixed." And he was right. He could get it fixed. He ran the show like a plantation, and he often was more powerful than the administrator of the VA in getting things done. And he could get it fixed. But what kind of system should we have if it's only on who you know and the ability to persuade that person to get you benefits? That's not a fair system. And so we filed a lawsuit challenging the BVA chairman's signature list. He had a signature list that said, I have to sign off on any board decision in which the claimant, the appellant, the veteran, lives in a district that a member of the House Veterans Affairs Committee oversees. So he's going to make sure that those people are treated well because they're on the House Veterans Affairs Committee, which passes legislation that controls the VA. So it didn't take long for the VA to invalidate, after we filed suit, that challenge, but it showed the unfairness of the system. And finally, in 1988, Congress passed the Veterans Judicial Review Act, which created the U.S. Court of Appeals for Veterans Claims. You've heard a lot about it from the two Amy's and Mel, and they've led an era of reform. Their decisions have, in the last 30 years, forced the VA to follow the rules that have been on the books for all that time. And so the system is much fairer. Before the court came into existence, the Board of Veterans Appeals would have an approval rate of 13%. It would vary each year, 13.1, 13.7, so much so that VA skeptics thought the BVA had a 13% quota system. Now, in the last number of years, approximately 30% of all those who appeal to the board have their claims granted, and another 40% get them remanded, a much better rate of success, and veterans have benefited from the court and its precedent decisions and its impact on veterans below. Then probably our greatest victory in the courts has been this Niemer case that some of you may have heard about, and it involved Agent Orange. How many people here, I know I can't see the arms and hands of the people who are watching this from afar, but in the room, how many people have heard about Agent Orange? Everybody. Well, one guy here is reading. He didn't raise his hand or whatever. It's a defoliant that was sprayed in Vietnam during the Vietnam War to destroy the foliage so that the enemy couldn't hide. And it had a contaminant in it, TCDD, or dioxin, that was very toxic. And Vietnam veterans started getting ill in the 70s who were served in Vietnam from a number of conditions that weren't explainable. And the VA took the position in unpublished fast letters, they called them, that the only disease connected with exposure to Agent Orange was chloracne, a skin condition. Finally, Vietnam veterans lobbied Congress so that in 1984, they passed a statute requiring the VA to go through a public rulemaking proceeding. And in this public rulemaking proceeding, the VA had to create an advisory committee of scientists to review the scientific evidence and decide what was related to Agent Orange. The next year, they published a regulation that said there's a connection between, and they said a cause and effect connection between exposure to Agent Orange and chloracne, but no other disease. Surprise, surprise, surprise. The same exact position the VA took prior to the rulemaking. Now, we challenged that regulation in U.S. District Court in 1986. That was before the Veterans Judicial Review Act. And you remember I told you there was a bar to judicial review. So how were we able to file a lawsuit in U.S. District Court if there was a bar to court review? And the answer is there was a loophole in the law recognized by 4 circuits that said the bar to judicial review didn't cover challenges to VA regulations. We filed in U.S. District Court in the Northern District of California. The Ninth Circuit recognized that loophole. And so the case stayed there. It was not thrown out due to lack of jurisdiction. And we argued, our main argument was the effect relationship that the VA required stacked the deck illegally because Congress didn't intend that sort of very strict causal connection in deciding what diseases deserve presumptive service connected status due to exposure. And we showed examples in other rulemakings where the VA had followed a much lower standard of a statistically significant association based on epidemiologic studies. And there are many, many rules in the Code of Federal Regulations that provide presumptive service-connected status, like chloracne did, based on a statistical association. So you all may be familiar with the rule from the last 10 years that says anybody who served in the military, who no matter how long after service develops Lou Gehrig's disease, ALS, is presumptively entitled to disability benefits for ALS. What was that based on? It was based on epidemiologic studies showing that veterans, all veterans from whatever era that they studied, that cohort, had a much higher rate of Lou Gehrig's disease than similarly situated people who didn't serve in the military. So the VA turned around and promulgated a regulation presumptively service-connecting that standard, that disease. And so we relied on that, on other rulemakings like that, to show the judge that this cause and effect relationship which the VA demanded was inconsistent with the statute requiring the rulemaking. The judge agreed, it validated the VA regulation, voided 29,000 denials of veterans who had applied for Agent Orange compensation, and required the VA to undergo a new rulemaking proceeding. Now, while VA started creating its replacement regulations, Congress stepped in. We helped lobby Congress to change the system, which they did in the Agent Orange Act of 1991. And what the Congress did was change the rulemaking process by getting rid of the VA's advisory committee, which were hand-picked people, some of whom worked for the chemical companies like Monsanto, who manufactured Agent Orange, and replaced it with a requirement that the VA contract with the National Academy of Sciences, who since then have been advising the VA for decades now. Anyway, every 2 years, the NAS would review the science and recommend to the Secretary of the VA what's connected to dioxin, what is related to dioxin. And Congress also adopted our district court ruling on what the standard should be. It said showing a positive association should get you presumptive service-connected status based on epidemiology in large part. And so those were two great parts of the Agent Orange Act of 1991. But there were two bad parts of that act. The bad parts of the act said when the VA, if it ever presumptively service connects a condition, it can't give retroactive benefits. It has to assign an effective date of the regulation of the date it was promulgated. So if in 1998, 7 years after the act, the VA provides presumptive service connection to multiple myeloma, let's say, people who apply for multiple myeloma who were Vietnam veterans cannot get benefits before 98, only after 98, even if they've had multiple myeloma since 88. And the second negative part is it didn't require the VA to notify anybody about its change in regs. So not everybody who previously applied for that disease would know that they can reapply. So how did we in NEMR get the VA to, in effect, override that by requiring them to identify everybody who previously applied and automatically re-adjudicate their claim and get benefits retroactive to the date of the claim that was denied whenever the VA adds a disease to the list. And here's a secret about how we were able to do it. Is this being taped?
Yes.
Can we block it out at this point?
Jordan, where's our director?
No, I'm guessing, no, he says no. He says you can't do it. Well, I did promise to come out here, and I was told that you were taping. And I have this in here in my speech to tell you the secret, so I guess I'm stuck. So here's how we did it. In February '91, the Agent Orange Act was passed. Now, we got Congress to put in the legislation that the VA still has to complete the NEMR replacement rule process. And Congress gave them 6 months to do it. And so the importance of that was if they service-connected some diseases as a result of NEMR, then these veterans whose claims were voided, and if they had one of those diseases, would get retroactive benefits back to 1985 when the regulation was invalidated. So it was how to get retroactive benefits. The problem was their advisory committee, which was supposed to advise them, rebelled. They were livid. I've read the transcript of their first meeting, and they rebelled, saying the VA had treated the whole process as a joke. That NAS, who was given by the Agent Orange Act $1 million a year to review the science, and the VA treated it out of their hip pocket, they said. And then Fred Conway, the head of the VA who was running the process, said, look, my budget was $45,000 a year. I did my best. So they wouldn't participate in the process. Now the VA was between a rock and a hard place. Congress required them to complete the rulemaking process, and these people weren't going to cooperate. So we reached an agreement, a consent decree, with the VA, overwhelmingly helpful. It said, whenever the VA, during the Agent Orange Act of 1991, adds a disease as presumptively service-connected to dioxin, VA is required to go back, find everybody who previously applied for that disease, and then redecide their claim under the new rule, which they'd win as long as they had the disease, right? All they had to prove is that they were in Vietnam, and this gets rid of the nexus requirement. There's no scientific proof necessary. If you applied for the disease and if you had the disease and you served in Vietnam, you'd get retroactive benefits to the date of your claim. Wonderful consent decree. Why did the VA ever sign that consent decree? My only guess is they never thought that they'd ever service connect anything, and so they never have to pay anything. But they were fortunately wrong. And Congress, the VA with NAS's prodding, has service-connected 15 different diseases, et cetera. So that's has resulted in $4.6 billion of retroactive benefits to over 100,000 Vietnam veterans and their survivors. It's been something that we're very proud of. And we're also very proud of a manual that you all have talked about earlier today, the Veterans Benefits Manual. When Congress created the Court of Appeals for Veterans Claims, there were very few lawyers who knew anything about veterans law. And so this was one of our ways of trying to increase the pool of effective advocates, to attract attorneys into a complex system so that they'd feel comfortable representing veterans, and also to upgrade, because we did a lot of training for the veteran service organizations who had non-lawyers represent them. The manual was written in a way that would help them as well. And so that's kind of the product, the written product we're most proud of, and we update it every year, and Lexis Law Publishing publishes it every year. A similar effort, a similar way to get more lawyers involved was the Veterans Consortium Pro Bono Program. Shortly after the Veterans Court was created in 1989, a very high percentage of those who appealed to the Veterans Court, over 80% appealed without a representative. The Chief Justice the Chief Judge of the Veterans Court, Frank Nebeker, did something very un-Washington. He told Congress, you've given us too much money. Get out of the court's budget, take some money back, and fund a pro bono program. And Congress ran that through Legal Services Corporation, and we formed an alliance with 3 other veteran service organizations and got that grant to recruit, train, and mentor volunteer attorneys to represent those people appealing to the Veterans Court. Now, I've talked about class actions, and NEMA was one of them. And unfortunately, the Veterans Court received a petition. It's not unfortunate that they received the petition, it's unfortunate what they did with it, from us and Paralyzed Veterans of America to adopt class action rules so you can file a class action with the Veterans Court. And very important, as the NEMA case showed. And the court rejected it, said, we're appellate court, we can't hear class actions. So that was very unfortunate. And so for many years, we couldn't file class actions in the Veterans Court. However, we had filed before the Veterans Judicial Review Act, NEMA, and this case, Giusti Bravo, to benefit veterans. In this case, very sad story. The VA in Puerto Rico, they have statistics of the percentage of people getting certain types of benefits, in this case, service-connected mental disorders, getting them what was their ratings compared to other regional offices. And they found that the San Juan Regional Office rated service-connected veterans for a mental disorder 100%, more than 4 times the amount of all the other regional offices. And so they sent down a SWAT team to figure out what was going on, and they issued a report saying Puerto Ricans rating Puerto Ricans is not working out. That was their language. Now, what does that mean? The adjudicators at the regional offices in San Juan were Puerto Rican, and they were hearing the cases of Puerto Rican veterans. So they thought they were being too liberal, to the tune of 4 times the average. So what they pressured the adjudication officer, the head of the San Juan regional office, to do was issue what to Puerto Rican veterans was the famous or notorious adjudication memo 82-3, which said, we've been too liberal in giving 100%. To be 100% disabled for a mental condition, you have to be in a nearly vegetative state of mind. Now, if you take that and you look at the Code of Federal Regulations, Part 4, which I'm sure you do when you look at what disability ratings should be assigned, 100% is not defined as being in a vegetative state of mind. It's a little easier to win, total social and industrial inadaptability. And so we filed a class action challenging that, which resulted in a settlement agreement requiring the VA to re-review all those rating reductions, there were over 1,000 of them, and sending them to a different regional office, which wasn't tainted, the Winston-Salem, and over 80% of the veterans got a rating, got reinstated, the 100% rating, retroactive to the rating reduction, over $60 million in retroactive benefits. So you can see how important class actions can be from Giusti Bravo and from the NEMA case. We've practiced a lot in the Veterans Court. We've filed 5,000 appeals since the court opened its doors. And in individual cases, just like Mel talked about, the courts issue precedential decisions that can help veterans. As Mel pointed out, sometimes she can shepherdize one of her victories and find thousands of decisions that cite it, meaning they probably benefited from it. Or it could mean they distinguished it and we're still denying you, but at any rate, it clearly has an effect. And this is one of the cases we're proud of because it deals with veterans of the first Persian Gulf War. And as you may know, Congress stepped in to make it easier for them to get benefits for the Gulf War syndrome, typical symptoms that occurred that were undiagnosed and there was no explanation for them, yet the VA was requiring proof of a connection between the undiagnosed illness and service, which is not what the statute says. And this decision, precedential decision by the Veterans Court, said that. We created in 2007 another pro bono program called Lawyers Serving Warriors. And we have big law firms around the country who take 400 cases a year that we screen, and we mentor them on individual cases before the VA, before the military on combat-related special compensation, for disability retirement, before the boards for correction of military records, upgrades and discharges. And so that program we're very proud of as well. Now here's a class action that we filed in the 2000s that was not barred, but excuse me, it wasn't in the Veterans Court. It was in the Court of Federal Claims, and it shows how the military system has roadblocks that are unfair, just like the VA system. Military disability retirement, or how many people here are aware of the circumstances in which a service member is discharged from the military with disability retirement? Raise your hand. Not all of you. Okay, let me explain that a little bit. If you have a disability that shows up during service that makes you unable to continue to serve, the military puts you through the disability evaluation system, and that system evaluates whether you can continue to serve due to your medical conditions, and if the answer is no, the military is supposed to assign a disability rating for the unfitting conditions based on the VA rating schedule. And if you get a 30% combined disability rating for the unfitting conditions of 30% or more, you're entitled to monthly disability retirement benefits, TRICARE for the rest of the veteran's life, for the rest of the veteran's spouse's life, and for the minor children and commissary privileges. If, however, you get less than 30%, 0, 10, or 20, you're given a lump sum medical separation payment and nothing else. And so in 2008, Congress, a joint session of Congress, held hearings about what the what the physical evaluation boards, the military, was doing in these cases. And they had a commission look at the differences between the VA ratings and the ratings assigned by the military departments for the same disabilities under the same VA schedule for rating disabilities. And they found the military ratings were much different and much lower. They said in the joint committee hearings that the military was lowballing the disability ratings so they didn't have to pay TRICARE and all those other benefits. And they did something about it by creating a new agency, the Physical Disability Board of Review, so people could apply and get an upgrade and retroactive disability retirement benefits. And they also passed a statute saying, remember when we told you that you have to follow the VA rating schedule? We mean it, we mean it, we mean it. And so the military did much better after 2008, but what about people who were discharged before 2008? And that's where this Sabo lawsuit came in. Those who served in Afghanistan and Iraq were diagnosed in service with PTSD. They were discharged through the evaluation system, found unfit, and they were signed less than 30% and given medical separation, thousands of them. When the VA rating schedule, 4.129, says if you have trauma or stress in service that makes you unfit to continue to serve, you should get at least a 50% rating. The military said, we don't have to follow 4.129. It's not a disability rating schedule, it's a convalescent rating or something that didn't count. And there were 4,400 class members in that suit. The military tried to come up with a way to only give them disability retirement for 6 months and then reevaluate them by the Physical Disability Board of Review. We didn't accept it. We reached a settlement where the military had to assign the VA rating. And so almost all of the 2,200 people who opted into the class got a higher rating, and 1,100 of them had been medically separated. So 1,100 of them got permanent disability retirement retroactive to the date of their separation. And so a great victory for them. I'm going to skip this over because my time is running short and you wanted me to give some time for questions. So let me skip over this statute and cover this case Staub. Staub has to do with reimbursement of medical expenses incurred at non-VA facilities. So a veteran who's getting their health care from the VA has a heart attack or an automobile accident and needs to go to an emergency room. The VA facility is too far away and their life is at stake. So they go to a non-VA facility. They get treated, their bill runs up, and Congress has provided a statute which allows them to be reimbursed or requires that they be reimbursed. And the VA had a regulation that said, if you don't have any health insurance, we'll reimburse you for, let's say you ran up a $45,000 bill, we'll pay the hospital $45,000. But, they said, if you have health insurance that covers part of it, let's say it covers 40 out of the 45,000, we're not going to pay the other 5,000 because you have other health insurance. Now here, the veteran helped the VA by getting health insurance, which they might have paid for or their employer paid for, and the VA's would only be on the hook for 5,000, and they're not even willing to pay the 5,000, and the veteran's on the hook for the 5,000. So Congress passed a Fairness Act in 2010 saying that's not what we meant. If the person has other health insurance, you're the secondary payer. And so the VA didn't think that Congress effectively did what they intended to do. So they didn't change the regulation. So they kept denying people with other health insurance. So we filed the Staub lawsuit, which resulted in the court invalidating that regulation, saying you're the secondary payer, you have to pay them. So we felt very good, walked around pretty good, except the VA instituted a moratorium on the 300,000 pending reimbursement claims after the Staub decision and wouldn't decide them until a new rulemaking proceeding was conducted so that they could process the claims. And in the new rulemaking proceeding, the rulemaking resulted in a rule beginning in 2019 that said the following. The statute, by the way, said we're not going to reimburse you for co-payments. The regulation says We're not going to reimburse you for co-payments. And then they added the words deductibles, and then they added the words coinsurance. Now, how many of you have health care benefits? There are only, as you may know, there are only 3 animals when you go to an insurance company. They'll pay the full amount except for a co-payment, which is usually a very small amount of money. The deductibles for a year that you have, and some people have $1,000, $500,000, whatever it is. And the rest of it is coinsurance, where a percentage of it will be paid by the health insurance company, and the rest is on you. So the only payments that the veteran would have to pay were these 3, which the VA said they wouldn't pay. So their rule in 2019 came out the same way as the pre-Staub rule, meaning we're not going to pay any money. So we went back to court, except we were helped by a very important development. The Yale Law School Clinic had filed an appeal to the Federal Circuit from a denial of a class certification motion in a delay case called Monk. It went up to the Federal Circuit, and the government in the Federal Circuit said the court has class action authority. They disagreed with the position of the VA below, and the court, the Federal Circuit, in a very strong opinion, said the Veterans Court has class action authority, and it's going to help ensure fairness, consistency in the VA process, and have access to lawyers who can represent them. A great victory. And so we then went to court challenging the VA reg that I told you about. The court certified the case as a class action, overturned the regulation, and ordered the VA to re-adjudicate 75,000 decisions, claims that it had denied because of deductibles or coinsurance. And unfortunately, the VA has appealed that decision to the Federal Circuit, as well as another decision in a certified class called SCORE. And the VA hates these class actions. Hate. And what they want to, they'll say the only class actions that should be allowed there are those based on delay in VA decision making. But anything dealing with a substantive regulation or policy is off bounds to class actions. That's what they want the Federal Circuit to hold. And there's an argument in our Wolf case on December 7th, and we'll see where that leads us. I'm just about done and ready for questions, but this case Mel already talked about. We got Mel's help on the Saunders case about disabling pain being a compensable disability. Here's another, we brought a delayed class action, GODSE, which was successful, although its scope was more minor than the Monk case. And I'm going to skip this over, but this has to do with Blue Water Vietnam veterans. And the Niemer consent decree, we went back to court for the 4th time to enforce the consent decree. And recently, the district court ordered the VA to redecide 60,000 Navy Blue Water claims that had been denied based on their illegal boots on ground rule. And I'm going to have to skip this over because there's just not enough time for me to talk about all this, but we have lawsuits on the military side of the fence dealing with the Navy and Marine Corps, which really have promulgated policies that prevent people from getting military disability retirement in different ways than they did before. They did before by giving them less than a 30% rating, but they've been forced by Congress to rely only on the VA rating. So they've figured out some other ways that they don't have to give disability retirement, which were challenging in cases like this. We conduct webinars as another training facility, training detail that we employ, and this discusses it's not a COVID-19 picture. Instead, it's a pictorial of our different activities, our different class actions, training, publications, etc. We've just added a burned claims assistance program to represent veterans exposed to burn pits, which seems to be the Agent Orange of this new Iraq-Afghanistan generation. So I'm sorry for going over a little, but I know I'm keeping you from eating. That's terrible.
Yes, so thank you, Bart, for our many, many. We are going to take the 90 people on live stream can't smell the delicious barbecue that is permeating this room. But we are, while Bart is here, I want to make sure that we answer any questions that you have. And for those of you who are live streaming, if you want to type them in the chat, the students are prepared to run your questions down to Bart. He is the godfather of veterans benefits. Is that okay?
I guess.
Yeah. He's, I have such great admiration for Bart, and his work inspires me every day. It's not about me, but it's just such a wonderful thing to have somebody like Bart motivate us in our work for veterans. So that said, let's have some questions and answers.
Sure. Yes, my name's Steve Skolnick, and I'm a local retired attorney. And I'm really going to make more of a statement, but this is my statement.
Okay.
And please correct me if this protection does exist and I've missed something. Prior to COVID, I would be coming to these trainings, and I think that we do have a real respect for our veterans, and some of the most impressive people that I've met in terms of veterans law have been out of the Veterans Clinic here. But since I have such an esteemed group of people who've really made this their lives work, this is what I'd like to say, and I'm not going to be the one to carry this, and it might never happen, but I'm going to put it out there, is we would get together and we would say, you know, we would really like to help veterans out, but we're retired and we don't carry insurance. And we would love to do pro bono work. So all I'm going to say, and I'm being purposely vague, it would be wonderful if on a policy level, there could be created some appropriate liability protection, and then I think you would get a number of us who would love to help veterans and take on a few cases. But I leave that to you folks, the expert in the field, and anything you could respond to in that regard would be appreciated.
Okay, I will say that for our Lawyers Serving Warriors program and the Veterans Consortium Pro Bono program provide malpractice insurance to lawyers, including retired attorneys, who take cases from those programs. But I think your statement goes further than that. It would be nice that any retired attorney would be covered to do a pro bono case individually on behalf of a veteran. That's an interesting topic, may require legislation or something, but well thought of. Yes?
Hi. I'm Pat Rowe Kerr, and I'm from Jeff City, and I'm the former State of Missouri Veterans Ombudsman. I am not a lawyer. I am a retired court reporter, and obviously I have been taking care of veterans, helping them navigate systems, educating them, providing advocacy since '02. So I have lots of boots on the ground experience, as you referred to it, which I appreciate from your perspective. I would simply like to encourage those listening and those that are here. When you are prospecting or working with your service member or your veteran, please don't ask them if they are a veteran when you're getting started. Many of our older folk, the one that we really need to access, don't consider themselves veterans because they say, I didn't get off the boat, I didn't shoot a gun. or perhaps they were given significant misinformation from the Department of Defense. So we ask folks to put into their intake forms, did you serve in the military? Everybody can answer that. And once that question is answered, you can run wild with helping them get the appropriate services. And that'll actually help you get backwards for many of those guys and gals that have said, hey, I don't get any benefits, when in fact, they don't even open a piece of mail that comes from the VA because they were told the wrong thing. Simple example, I go to Fort Leonard Wood on a really twice a month basis, and the guy said, I'm paid for by DOD and I'm paid for by the VA. We want to get him out at 25% VA rating. Did you hear what I said? 25% VA rating. There isn't one. But that's taking them under the 30, right? And then lastly, I would just tell you that if you're a veteran that you now have determined is truly a veteran, has a rating that could allow them to be medically discharged, many of them don't feel, and a lot of this is about emotion and feeling, many of them don't feel that a medical discharge is as honorable as an honorable. If they have a medical discharge, we in the world of advocacy who work with nonprofits nationwide, we have a great ability to help them get financial resources that can provide them with additional help while they are trying to navigate and wade through the arduous system. It's for you.
Thank you.
Thank you.
Hi.
You've shown us some landmark decisions and statutes that have happened in the past for veterans' compensation and benefits. If you had the ability to craft any legislation or any statute or regulation you could, if Congress just would listen to you and you alone, what does the future of veterans' benefits look like? Like what is the next game changer statute or decision?
You should have written me 48 hours ago when I had a chance to think about it. The first thing that comes to my mind, there's a number of technical amendments that would be very important to make to this new modernized AMA process that the VA really was very clever in how they solved this. They went to Congress and said, the VA system is terrible. We're not doing well for veterans. There are delays up the gazoo, and veterans aren't being treated fairly by us because of an antiquated system. And we want to make it streamlined. And so it was a great public relations campaign to get things to change. And there were things that needed to be streamlined. They got rid of the need to file many forms that a veteran had to file to get through the system. But while they were doing it, they made it difficult for veterans to submit new evidence. They don't want any new evidence. It made it difficult if not impossible, for veterans to get hearings at regional offices. They used to get hearings all the time at regional offices. Now, the only way to get a hearing at a regional office is between the filing of the claim and the date of decision by the regional office. And so you have to immediately ask for it. You can't ask for it afterwards. You have to file a supplemental claim or appeal. And when they do ask for it, they don't give it to you anyway, because they don't want to do it. So they've saved tremendous amount of time not having regional office hearings, which are important to avoid having to go to the Board of Veterans Appeals. Then you've heard the wait at the Board of Veterans Appeals for hearings. So there are all kinds of tricks of the trade. Let's say no duty to assist at the board. You've heard the two Amy's and Mel talk about that. Now, they had a rationale which was decent. The reason we need no duty to assist at the Board of Veterans Appeals, they said, was because if there's a duty to assist and new evidence was created, we'd have to go get it, and associate it with the claims file so that the board would review it, and then some more evidence would come in and it would delay everything. Now that's a rational reason. But you didn't have to write it that the duty to assist as a whole doesn't apply. It's just that new records after the RO decision didn't need to be put in, but that doesn't mean you have to treat them in a process way terribly. And so I would fix that. So there's a number of problems of which the two Amy's and Mel talked about that would be very helpful to fix. That's my 2-minute answer to your, the 2 minutes you gave me to think about it.
Thank you.
In your experience, what has been the main argument against presumptive service connection? Is it a floodgates policy argument, and what's been your response to those?
The main argument against it or for it, presumptive?
Against.
Against it? Well, I'll give you the reasons for it, and then I'll tell you the against it. With the judge, you're supposed to answer the question first. I'm going to do it second with your permission. The beauty of a presumptive condition is you don't have to prove, and it's difficult to prove, a connection by submitting evidence from a medical professional. And that's difficult for veterans to get. And it makes it really into more of a trial, and it's very difficult for veterans to prove. Then the VA gets their own medical opinion, and there's conflicting evidence in the record. It's a mess, often. With presumptives, you don't have to, it gets rid of that evidentiary problem and makes it much easier for a uniform system to be applied. The argument against it is every Tom, Dick, and Harry who fits within the presumption gets benefits when, if you really looked at it, the likelihood that their disease is connected to something that happened in service is de minimis. So while I'm very pro benefits for people exposed to Agent Orange, the rules now, the presumptive rules, are that a veteran, Vietnam veteran, who gets prostate cancer at the age of 91 gets benefits under these presumptive rules for service-connected disability benefits. If he's totally disabled, that's like $36,000 a year tax-free. And if you guessed or did a scientific analysis of the likelihood that 5 decades after the guy served in Vietnam, and maybe he just landed in a plane there for 1 day, are you going to tell me realistically that that person developed prostate cancer as a result, I'm giving you the most extreme example, of a pit stop at an airport in Saigon? So that's the negative aspect. But it's a system of mass justice. You can't, you can't have a trial in each case. It would cost too much for everybody. And so the presumptives make it more easy to administer in a system of mass justice.
Thank you.
I think what happened here is Angela went out to get lunch for herself. And so she's not here to administer this question and answer session. It looks like there's no more questions. So Angela, could you signal me what I should say?
I was coaching.
That's okay. I just made a little joke. Oh, we... All right. Here we go.
We had a, oh, yes. Yeah.
Oh,
We had
you have a
few-
question?
Yes,
Oh,
we
I
had
thought
a
you
few
were gonna-
questions from the chat. The first one was, does the veteran's poor treatment during discharge process affect the benefits decision?
Could you repeat that slowly?
Yes. Does the veteran's poor treatment during the discharge process affect the benefits decision?
Let me help. So the person on the chat said that he was helping a veteran who had been discharged in 1959 for being homosexual and recently got honorable, which is fantastic. And he was wondering how that impacts the benefits decision.
Well, the upgrade, this is an upgrade to honorable. If the person had a general under honorable conditions, it's possible that the VA reg prevented them from getting VA benefits. And I think the VA is in the process of changing those regulations so that the person can get access to VA benefits. And of course, whatever stigma there was for having a general discharge or even lower, and having homosexual acts or whatever in your DD 214 have been changed by this upgrade. So the stigma should be eliminated, and it looks like the VA is changing the rules so you get access to VA benefits.
The other one is from David Wells, who's a veteran service officer here in Missouri, and he made the observation and question about, can we do anything to help our veterans who served in Thailand who were exposed to Agent Orange? And it seems like if Blue Water Navy, you know, we've got the 12 nautical miles now, and those guys in Thailand were working in, you know, very close to the edge of runways and the perimeter and all that. How can we make it easier for them?
Well, I think there are some bills that are unlikely to pass that are trying to address that situation. And we have cases of ours at the Veterans Court where we're trying to get the Veterans Court to make the VA more uniform in how they decide the cases of people who served on the Air Force bases that the manual identifies as those in which Agent Orange was sprayed.
I don't see anybody behind us, and the smell of barbecue is stronger than ever. So we will adjourn for lunch and come back at 12:30 for ethics. Thank you, Bart.
Yeah.
process.
Thank you.
Welcome back. I hope lunch was great. I'm not a paid spokesperson, but thank you, Buckingham's, for the barbecue. Hi, everybody. My name is Caleb Rutledge. I'm a third-year student here at Mizzou Law. I'm also part of the Veterans Clinic. I've had the privilege to work with 3 veterans with filing new claims and helping with appeals. And now I have the honor of introducing our 2 next speaking guests. Professor Reeves has roots with Mizzou Law and Mizzou. She got her Bachelor's of Science in Agriculture, I believe, and then got her JD a few years after that. Following that time, she has served with judges and with the Missouri Attorney General's Office with the Criminal Appeals Division. She's argued successfully hundreds of criminal appeals before courts of appeals and the Missouri Supreme Court, and she's graciously joined us here at Mizzou Law this year. In her time in Mizzou Law, she also worked for the Veterans Clinic, so she has a heart and a passion for this line of work. Along with Professor Reeves is Alex Cassell, and they're going to be giving a presentation on the cloud, since so many jobs, so much information is being used with virtual clouds, whether it be Box or Dropbox. So here to present to us the ethical responsibilities and duties of a virtual lawyer, please welcome Professor Julia Reeves and Alex Cassell.
Thank you, Caleb, for that. I hope everyone enjoyed their lunch. Hope everyone tuning in remotely also was able to enjoy their lunch. As Caleb said, I am the new Associate Professor of Law here at Mizzou and the Clinical Director under Professor Drake. I just came here from the Attorney General's office, but I was one of the first groups to graduate from the clinic, and the work has profoundly impacted me. I was actually here at the symposium that I found out we had won the military sexual trauma claim that we worked so hard on for our original client, who unfortunately recently passed away. So I do want to take a moment to thank our amazing speakers, Bart, Stichman, Mel Bostwick, the Amy's. We are so fortunate to have some of the best advocates here with us to teach us, and that's due to the countless hours of Professor Drake, our staff, Martha Bradley, our fellow, and our students, of course, have worked so hard to pull this off, so thank you all. Yes, thank you. I do want to introduce Alex Cassell. She is a third-year law student here from St. Louis who is currently in the Veterans Clinic. She is a teaching fellow for both torts and criminal law, and she works at the Thomas Law offices in Columbia in her limited spare time. She co-authored this presentation with me, and I am so happy she is here today to help me present. Today, we're going to discuss what guidance the professional rules of conduct give us in relation to using technology in our practice. There are 3 key rules to understanding our obligations when it comes to emerging technologies: competence, confidentiality, and supervision. The most important takeaway, if you only remember one thing today, please remember this: we have a duty to maintain technological competency. And we'll get into that. But first, let's watch a quick video demonstrating what happens when attorneys use technology that they are not familiar with. I think some of you might know what's coming. Oh.
I'm not sure our live streamers.
Is there... So we're having technological glitches as we speak. Can we see about playing the video? Someone's coming down. This is all a part of the interactive process of emerging technologies. Thank you. it's gonna be that one, yep. Just a quick note. Is this your only video? Yes. Oh, yes. Just a quick note, since we're going to all enjoy a laugh at this lawyer's expense once again. I'm sure everyone watched him. I did do some research, and this was shared with the lawyer's permission. So the judge didn't just make him a YouTube star without asking him first. So we all can learn from this poor cat attorney. I don't like the idea that this is this lawyer's claim to fame. Okay, great. Thank you all so much. Maybe come back. Yeah, I think we're going to move on without it. But thank you all. Our IT has been wonderful today, and I really appreciate the fact that they are here to make this go as well as we can. Although now, actually can't advance it now. Okay, so today we're going to discuss, well, to go back, there have been numerous growing pains and specific issues arising concerning the use of new technologies since COVID-19 hit, and the use of Zoom and WebEx court appearances became the norm for almost everyone. Here in the video, the technological error was, of course, forgetting to turn off a pre-existing filter and not having the independent knowledge of how to change it back quickly or turn off the camera. It's ironic that as we increase our use of technology like Zoom, we are increasing both our connections as well as our remoteness by sacrificing our in-person systems. Our legal work has changed as technology advances and makes processing, transmitting, and storing client data both easier and more remote. Our knowledge of technology helps us in our practice, but it also helps us provide clients guidance as they seek to navigate complex decisions dealing with the same technologies. As counselors, we have a crucial role in guiding the use of technology in our practice and our clients' matters. Sound legal advice from attorneys will protect clients with emerging liabilities as laws and rules are developed to address the issues of the use of technology in society. And I do want to share a quick story, a funny anecdote, since we didn't get to watch The Funny Lawyer. The very first time I appeared to the Supreme Court via Zoom, my camera and microphone did not connect. And Judge Draper said, "Counsel, I don't think it's working." And in those few seconds of panic, because I was, of course, the appellant and had to argue first, I just hear him laughing and saying, "You can try logging off and logging back on, or go find your 12-year-old nephew to help you out." So fortunately, I was able to log off and log back on and proceed with my argument. So it's important to be able to adapt and overcome. So today we're going to discuss three main issues, although of course there are numerous things we could talk about relating to emerging technologies. We're going to have to leave those for another day. But the first is using cloud-based technology like Box and Teams for client storage, the duty of technological competence, as well as the duty to supervise and other rules implicated, reasonable efforts and best practices from the ABA, as well as our own Missouri Bar. And then Alex is going to discuss emailing clients, the advantages and disadvantages, the rules implicated, and disclaimers. And finally, we're going to end with talking about metadata, which is a very easy way to inadvertently disclose information that not all of us are aware of. So first and foremost, the duty of competence. We all know this rule. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. In 2017, the Missouri Bar adopted the ABA's 2012 comment about which states, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engage in continuing study and education, and comply with all continuing legal education requirements to which the lawyer is subject. What does this mean? Technological competency is a moving target. As technology evolves, such as keeping up and being able to use Zoom and WebEx, so must we evolve. Effectively uploading and protecting client information might be different today than it is tomorrow. Using email properly, hopefully everyone knows how to do that, but we will be discussing it today. This also implicates right now knowing about encryption and metadata. These are all things we did not have to know just a few short years ago. Another duty that is implicated by emerging technologies that we will discuss more in a few moments is the duty of confidentiality, Rule 4-1.6. This rule, as we know, generally prohibits us from revealing information relating to the representation of a client unless there is an exception. In 2017, again, the Missouri Supreme Court added an addition to this rule, 1.6c, which states that a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of the client. This applies to electronically stored information and is why this rule was added. This rule makes the duty of technological competency even more crucial. Note, there is no violation of 4-1.6c if the attorney has made reasonable efforts to prevent the access or the disclosure. I think some attorneys probably did the dreaded reply all, and they said, we need a rule about this. All right, the duty to supervise. This rule discusses, with respect to a non-lawyer employed or retained by or associated with a lawyer, a partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurances that the person's conduct is compatible with the professional obligations of the lawyer. Nothing about technology, but in 2012, it was modified. The original title of this rule was Responsibilities Regarding Non-Lawyer Assistants, with a T. They modified it to this, Responsibilities Regarding Non-Lawyer Assistants. They did that in order to address the evolving use or the emerging use of technology in the practice, including outside vendors' technology. So what do the comments say? As always, we go to the comments for guidance. Comment 3, non-lawyers outside the firm can include the use of technology. A lawyer may use non-lawyers outside the firm to assist the lawyer in rendering legal services to the client. Examples include using an internet-based service to store client information. When using such services, the lawyer must make reasonable efforts to ensure that the services are provided in a manner that is compatible with the lawyer's professional obligations. The comment goes on to state that the extent of this obligation will depend on the circumstances. These circumstances include the education, experience, and reputation of the non-lawyer, the nature of the services involved, and the terms of any arrangements concerning the protection of client information. The legal and ethical environments of the jurisdiction in which the services will be performed will also be considered, particularly with respect to confidentiality. The comment then references multiple other rules that this rule implicates: competence, allocation of authority, communication with your client, confidentiality, professional independence, as well as the unauthorized practice of law. But the ultimate conclusion is that when retaining or directing a non-lawyer outside of your firm, a lawyer should communicate directions that are appropriate under the circumstances to give reasonable assurance that the non-lawyer's conduct is compatible with the professional obligations that we have. So, what does this look like? If you're using artificial technology to do things that a human did for you before, like scanning documents to identify missing clauses, then you as the attorney still must check and make sure that the work is accurate. I will tell you a real life story. Westlaw now has Quick Check, which you can run your briefs through. Quick Check misses important points of law that have not been clearly articulated in other opinions or that are on the cutting edge of the law. Sometimes it misses things that are not so new. I was writing a brief this year about the corroboration rule. Does anyone know what that is? Criminal law, we used to have a rule that the testimony of victims of sexual crimes, their testimony had to be corroborated and uncontradicted. This put the Court of Appeals in the position of fact finder, so it was actually against the law. State v. Porter abolished the corroboration rule in Missouri. The Supreme Court got rid of it. That was in 2014. I was writing this brief in 2021, and Westlaw did not catch that. So, point, there's no replacement for your own knowledge as an attorney, understanding the rules and applying them. Another important thing to do that we will discuss is communicate with any third-party vendors and affirm confidentiality, like who from their company is able to access the files that you're using and that you're storing, and what to do in the event of the loss of data and recovery. Who owns the files? Where are they stored for jurisdictional purposes, etc. Best practices tip, Rule 4-1.6, communication. Tell your client what technology you're using and get their approval for it. A client may give informed consent under the rules to forego specific security measures, but this requires you give them adequate information and an explanation about material risks and reasonable alternatives to the proposed course of conduct. All right, can you use cloud-based technology? From the horse's mouth, the Missouri Bar issued an informal opinion in 2018 stating that attorneys may use cloud-based technology if they both maintain competence in its use and make reasonable efforts to safeguard confidential information from accidental disclosure as warranted by the particular facts and circumstances of each client's matter. The attorney should carefully read the cloud computing's provider's terms and conditions of service. I know you're all very eager to go home and do that. The informal opinion goes on to discuss the best practices. The attorney should ensure adequate provider policies and practices. These should be written policies and practices as to the ownership and security of client information and attorney and provider access to client information. What is considered good policy and practices for these cloud services will be evolving as the technology changes. Attorneys should consult with qualified information technology professionals, take CLE courses on technology and practice, and engage in regular self-study of reputable materials in order to maintain competence. The the Missouri Bar informal opinion goes on to talk about what reasonable efforts include. Reasonable efforts to safeguard confidential information may include, but are not limited to, ensuring that you have provider policies and practices regarding security measures for the storage of client data. This includes password protection, encryption, which we'll talk about, backups, access by provider. You also want a prompt notification in the event of a security breach so that remedial efforts can be taken immediately. Ownership of data solely by the attorney or your firm. No access rights to client information by the provider or third party. Regular data backup. Have a plan in place for handling client information if the relationship with your provider is terminated, just as you have a plan in place for providing the client with their file if the relationship is terminated. You should have a plan in place for this. Compliance with the applicable laws of your jurisdiction regarding data storage and transmission, reliable attorney access to data and plans for transition of attorneys leaving the practice, and you want your data to be stored domestically or in a jurisdiction subject to the laws of the United States. Now, I'm going to hand it over to Alex, who's going to talk to us about emails and what the ABA guidance is on using them.
So one of the largest ways that we transmit client information is through the use of email. And emailing with our clients and coworkers is so common today that it's just like second nature. It's convenient, quick, simple, easy to use, comes at little to no cost. It's also what everyone uses, so it provides for faster communications, and everyone is always checking it. And I'll bet that a lot of you are even checking your emails right now. But email, as we know, also comes with a lot of drawbacks as well. So because it's a main method of communication and because it's so quick and easy to send an email, it's going to obviously lead to a huge influx of emails sitting in your inbox. It can be overwhelming to have so many, and you have to sift through and discern the most relevant and the most pressing to respond to. Emails are also treated more informally sometimes than, say, a written letter, so it can lead to more mistakes. And also, if you need to recover deleted emails for a document request for litigation, this can be actually pretty costly. So emails are actually considered part of your client's file. The ABA released an informal opinion in July of this year that said both emails with the client and emails relating to the representation of the client are part of the client's file. So what does this mean? It means that you need to be retaining them in accordance with the Missouri Rules of Professional Conduct. And the specific rule for file retention in Missouri is 4-1.22. And it basically just says that you need to keep these emails as part of the client's file for 6 years after termination of the representation of the client. So the other thing about emails is the prolific use of disclaimers. You might see something like this, and you might use something like this in your emails. Important: the contents of this email and any attachments are confidential. It may also be privileged or otherwise protected by work product immunity or other legal rules. They are intended for the named recipients only. If you have received this email by mistake, please notify the sender immediately and do not disclose the contents to anyone or make copies thereof. Now, in the 15 brutal seconds that it took me to just read that, I'll bet almost everyone totally zoned out. I even zoned out. It's boring, and that's kind of the point. So you can imagine what people do when they see these in their emails. They're not going to read them. They're going to ignore them. And there's actually research that indicates that less than 10% of people who receive emails with these disclaimers don't read them at all. And that statistic, I'm sure, is not that surprising to anyone. And these disclaimers become even less effective when you consider that many firms automatically have them included in every email that gets sent out. So this means for a lot of firms, it's getting included in your non-legal emails. It's getting included in your emails for making lunch plans. So if you want them to be as effective as possible, it's important to only include them on emails that actually contain confidential information. And also, most of these disclaimers are put at the end of email messages. So if you want them to be more effective, putting them at the beginning before the recipient were to read the information contained in the email, that can be more effective than having them at the end. So in 1999, shortly after email use was really starting to pick up, the ABA released a formal opinion that said lawyers, in fact, have a reasonable expectation of privacy when it comes to using email. So this meant that under the rule of confidentiality, which was ABA Model Rule 1.6, using regular email was a totally acceptable way to maintain confidentiality of information relating to a client's representation. And as we know, technology has changed a lot since 1999. So not only are we using and relying on technology now more than ever, but that comes with an increased risk of inadvertent disclosure of confidential client information. So in 2017, the ABA released an updated formal opinion on how to comply with the core duty of confidentiality in an ever-changing technological world. And they gave specific guidance on issues that have arisen relating to protecting client confidentiality in email communications, which we're going to talk about. So like Professor Reeves discussed earlier, lawyers have a duty to maintain technological competence. And Model Rule 1.1 was changed in 2012, like Missouri's competence rule was changed in 2017, to include this comment about maintaining this technological competence. So for example, you would likely be violating this duty if you couldn't respond to emails or compose an email or create an electronic document. And we're also all expected to use electronic filing on CaseNet, so not having a basic understanding of how CaseNet works or how to appropriately use it could lead to missing filings, and that would likely be a breach of your duty of technological competency. So step one is knowing how to use things like email or CaseNet. And the rule doesn't impose any heightened or specific standard on things that you specifically need to be able to do. The standard is simply reasonable efforts. So we have to ask, what do these reasonable efforts look like that we need to be putting forth? The answer, of course, is it depends. So comment 18 to Model Rule 1.6 gives us some non-exhaustive factors to consider. And these are going to include things like the sensitivity of the information that you're dealing with, the likelihood of disclosure of this information if you don't include additional safeguards, the cost of those safeguards, and the extent to which those can adversely affect your ability to represent your clients. And this could look like placing so many restrictions or security measures on a device or software that it becomes just too difficult to use. So when dealing with particularly sensitive information, such as things like medical records, it's important to remember that the higher level of HIPAA confidentiality applies only to covered entities. And this is going to be things like healthcare providers or healthcare facilities. And the privacy rule for HIPAA protects personal health information, or PHI, from disclosure. And PHI is anything that's individually identifiable health information. So this means anything that the reader should know is tied to the patient, like if it's tied to a name or even a patient's room number. So these covered entities have to have patient permission before they can give information like medical records to others on the patient's behalf, which is why we have HIPAA authorizations for our clients to sign. But once you have this HIPAA authorization from your client, the level of duty with regard to their medical records is actually the same as any other client paperwork. Now, that being said, if you're dealing with information that's particularly sensitive in their medical records, sometimes a reasonable effort that's going to be employed is something like encryption. It's the highest standard that you can probably use. And before we get into the specifics on those reasonable efforts, I want to take a minute to talk about what encryption is. So end-to-end encryption is a process in which information is coded and sent in a scrambled format. So anyone who were to intercept it wouldn't be able to read it because it would just look like a bunch of scrambled numbers and letters. And it involves the sender encrypting a message and the recipient decrypting it with a key. And this key is just a combination of letters and numbers. So once the recipient receives the email, their email will use their private key to decrypt the information, which will unscramble the data and make it readable again. And this is all automatic, so the actual recipient of the email doesn't typically need to do anything. They might just see something flagged on the email that it was sent as encrypted. And sometimes on the part of the sender, this is automatic as well. So it might take place without you even realizing it. Your email can sometimes flag information such as credit card information if you're sending that over as particularly sensitive, and it will just go ahead and encrypt it before it sends it. But if your email doesn't automatically encrypt the information, it will have an option to do this, and depending on what information you're dealing with your client, you might need to select that option. So a lot of these reasonable efforts that we're going to talk about could be costly, and that might actually implicate the duty of communication, which is Model Rule 1.4. And that may require you as an attorney to discuss these security measures with your client. If you're using something such as encryption, or if there's anything that you're using as a security measure that's going to come at any increased cost to the client, it's important to communicate that with your client beforehand. So, more specific reasonable efforts. One of the first things you'll want to understand is the nature of the threat that you're dealing with. And in order to do this, you need to consider the sensitivity of the information like we talked about. So if you have client matters involving things like trade secrets, or you're dealing with an industry such as healthcare or banking, there's going to be a higher risk of data theft. There's going to be a greater incentive for people to get this information, so a greater effort on your part is going to be warranted. You also need to understand how confidential client information is transmitted and where it's stored. So this involves being able to identify every access point to your client's information, like the different devices that you and your firm use to communicate with your clients. You need to be able to identify how the firm's communications are created and being able to identify where your client data resides. You'll also need to understand and use reasonable electronic security measures, and these can include things like using secure internet access methods to communicate, access, and store client information, like using secure Wi-Fi or a virtual private network, using unique complex passwords, and also changing them periodically. You want to implement firewalls and anti-malware, antivirus software, frequently updating your firm's software, having procedures in place to disable if lost or stolen devices and destroy the information of your client on those devices. You also want to have multi-factor authentication to access your firm's systems, and also remembering that just because something is deleted does not mean that it's permanently gone. That may require additional steps to get rid of the information completely.
I'm going to interrupt you, Alex. Were any of these available 20 years ago?
No, definitely not.
So this is a great example of how the moving target of technological competence really is a very moving target.
Absolutely. So another thing, you might need to communicate with your client at the outset of the attorney-client relationship on what levels of security will be necessary for each electronic communication. Something important to keep in mind here is that your client's lack of technological sophistication might be something to keep in mind, and the limits of technology available. It may require you to use non-electronic forms of communication. And also warning the client of the risk of sending and receiving electronic communication on a device that a third party has access to. So this can be something like a device that's shared with their friends or family, or using a public computer at a library, things like that. You're going to want to warn them that in certain situations, if they're using this device that has third-party access, it can actually waive the attorney-client privilege and the confidentiality of communications. It's also important that you label confidential client information. So if it happens to get inadvertently sent, this puts more of an obligation on the recipient to promptly notify you of the inadvertent disclosure. And finally, it's necessary to train lawyers and non-lawyer assistants in technology and information security. This will probably look like just having policies and procedures and trainings in place for your employees in the use of reasonably secure methods for electronic communications with your clients. So a big way that lawyers can inadvertently disclose data is through metadata. And metadata, simply put, is data that describes other data. It's information that's attached to a document about that document. So for example, when your phone takes a picture, it stores all kinds of data that you don't even realize. The date it was taken, the information of the camera it was taken with, exposure time, whether flash was used, and the actual location that you took the picture. So sometimes in this instance, it can be pretty helpful. But with regards to sending documents to opposing counsel, it can actually be really harmful to your case. It can disclose data that you don't intend to share. So for something like a Word document, this could include details like the title of the document, the author name, keywords that identify the contents, but it could also include things like previous comments that you made on the document or tracked changes, which could reveal confidential client information. So if you're on the receiving end of a document that has metadata, the big question is, are you required to tell the sender that this document has this metadata? Missouri Rule of Professional Conduct 4-4.4b says that if you know, or reasonably should know, that it was inadvertently sent, then you have a duty to promptly notify the sender. So it's not going to be the case where every time you receive metadata, you need to tell the sender about it. There's still this knowledge requirement of knowing or reasonably should know that it was sent to you inadvertently. And determining this level of knowledge is going to depend on the facts and circumstances of each particular case. So let's take this scenario as an example. There's metadata on a document that was just sent to your opposing counsel, and it reveals a settlement position or your bottom line. Can the lawyer who received this information actually use it? The rules of professional conduct don't really provide much guidance. The receiving lawyer might actually be under an ethical obligation to use this information. Getting the other side's bottom line is clearly of great value to her client's case, and so the failure to use it could be a breach of the duty to her client. And logistically, with something like a bottom line getting inadvertently sent, there's not really a way to avoid using it. There is a Missouri Rule of Civil Procedure, however, that says if you receive information that you have reasonable cause to believe was sent inadvertently, you actually cannot read it, or you have to stop reading it if you've already started. So it has the same notification requirement that the ethical rule does, but this takes it a step further. So under the Rule of Civil Procedure, the recipient has to actually return this information to the sending attorney and delete or destroy the information and any copies that they've made, and also take reasonable measures to assure that the information is inaccessible. But it's important to keep in mind that this is a rule of civil procedure. This is not an ethical rule. So going back to our scenario, whether or not the receiving lawyer can use the information will depend on the particular circumstances. But regardless of whether or not he can use it, there would be a clear duty to promptly notify the sender. Again, sending something like a bottom line might be pretty obvious that it was inadvertently sent. And so one of the ways to avoid sending this metadata is just by getting rid of it. And it's called scrubbing metadata from a document. And it's usually just as simple as going into the document settings and somehow deleting it. But it really just depends on the document that you're working with. So if the document doesn't allow you to get rid of the metadata itself, there are also certain programs that you can install and it will do it for you. So scrubbing metadata is the only way to get rid of it in your document, so it's important that you do.
So this is a chart summarizing today's takeaways. So a fact that we deal with is that there are constantly new and emerging technologies, including cloud-based storage systems that allow for online storage of client data. The consequence is that this impacts different rules, including the rule of confidentiality, community, competence, and supervision. How to comply? There are several ways, including attending CLEs like this, limiting access to client data, reading those terms and provider contracts, and regular data backups. Another fact is that email is today used as the primary method of communication between attorneys and their colleagues, as well as their clients. The consequence is that it is quite easy to inadvertently disclose and breach your duty of confidentiality because it is simply the push of a button, and the wrong button could disclose it to quite a lot of people. How to comply, necessary measures here depend on the circumstances. You should use effective disclaimers, you should use encryption when necessary, and you should in general try to limit the chances of unauthorized third parties accessing email by discussing with your client when it is appropriate to email you and what they should be sending you over email, because they might be using a computer that has third parties accessing it. Finally, documents contain metadata. This can reveal a number of things, which could include important confidential information, and you should be scrubbing metadata from documents before you send them. Also, to note about metadata, there is a federal rule equivalent. It is Federal Rule of Civil Procedure 26B5, and it's the same civil procedure rule as we have in Missouri. So the takeaway from today, as an attorney, you should study and actively learn about technologies you utilize in your practice in order to maintain technological competence. This means using reasonable efforts to prevent the inadvertent or unauthorized disclosure of client information and exercise appropriate professional responsibilities over the conduct of non-lawyer assistants, which includes artificial intelligence and technology of third-party vendors outside of your firm. Focusing on these ethics rules that we talked about today and engaging in ongoing learning will help you in choosing what technology is best for your practice and help prevent breaches of confidential client information. If you have any questions about using technology in your practice, you can ask them now, or you can contact the Legal Ethics Council Office for Missouri, which is www.mo-legal-ethics.org. That's www.mo-legal-ethics.org. I saw a few writing it down, so I wanted to repeat it. They will issue an informal advisory opinion about any questions you might have in your practice. So I think we overshot it a little bit because we started late, but does anyone have any questions about using technology in your practice? Everyone feeling ethical? Everyone feeling tired from lunch? Are there any questions from the, I know I don't want to exclude our silent majority of online listeners.
No, I'm not seeing anything on the chat.
All right, well, thank you.
I don't know what to do about that, but cookies are coming, so that's good. And then we'll start our JAG panel at 1:45. So this is a good time to check your email.
All right, looks like everyone's back. We'll go ahead and get started. So just briefly, my name is Justin Bricky. I'm a temporary staff attorney with the clinic under a new program at the clinic called the Military Lawyers Transition Program. Under this program, the clinic employs recent graduates of the law school and the Veterans Clinic who've been employed, or accepted offers rather, with the armed forces or a federal law enforcement agency. So there's often a long delay between graduation and accessions into the service. In my case, it's 7 months, and so the clinic allows us to keep working, keep us from starving, and gives us the opportunity to use our new law degrees for a good use. Now it's my pleasure to introduce our esteemed moderator, Lieutenant General Richard Harding, for our next panel, which includes the 4 JAGs before you. Lieutenant General Harding served for more than 34 years in the United States Air Force until retiring in 2014. He was awarded a direct commission in the Air Force as a judge advocate military lawyer following his graduation from the University of Arkansas Law School in 1979. During his Air Force service, General Harding served as mission controller for a fighter aircraft squadron, the chief of acquisitions for combatant command, the commander of a Department of Air Force agency, the legal counsel for 2 wing commanders, the senior legal counsel for the commander of the 8th Air Force, the senior legal counsel for the commander of the Air Force Space Command, the senior legal counsel for the commander of the United States Strategic Command. General Harding was with President Bush during the 9/11 attacks and part of the advisory team on whether or not we could take action against civil aircraft. In his last role on active duty, General Harding served a statutory 4-year term as the Air Force Judge Advocate General stationed at the Pentagon. In that role, he served as a legal advisor to the Secretary of the Air Force Chief of Staff, and all Air Force officers thereunder. He professionally supervised 4,400 Air Force attorneys, judges, paralegals, and civilian staff in providing legal services to over 90 Air Force worldwide locations. He also served on the Air Force Corporate Board, making resource decisions regarding billions of dollars in national defense purchases. General Harding has traveled extensively overseas and in combat zones to advise commanders on the international law of armed conflict and their obligations. In his last few years in active duty, General Harding created a highly successful Special Victims Counsel program, which provides free attorneys to victims of military sexual assault, which Congress passed into law and was adopted throughout the Department of Defense. Upon retirement, General Harding and his wife Linda elected to leave Washington and moved to Columbia, Missouri to be close to their children and young grandchildren. General Harding now travels throughout the United States, teaching continuing legal education programs for the professional education group on subjects of the law of armed conflict, ethics, and contemporary constitutional law. He also serves as trustee for the Columbia College and an advisory board member on the National Crime Victims Law Institute. General Harding, I turn it to you.
Thank you very much. We have before you 4 judge advocates from different services, all of them elected, they weren't drafted, elected to come into the Air Force JAG Corps. And they're going to share their stories with you today. And we're going to go down from the end of the table forward. Major Joe Neely will be first, Lieutenant Larissa Tiller will be next, Captain Jared Murphy after that, and Janelle Murphy, I'm sorry, and Captain David, what do we got here? Rogers, roger that, all right. So let me turn it over to them, and they're going to tell you a little bit about their background. I got to tell you, when I was at their stage, I did a couple of things really well. If I can brag on myself for a little bit, I was a prosecuting attorney and a defense counsel, and so, as was mentioned, I was a mission controller, and those were the skills that I had. And I felt very good about those, and then I had a couple of very good bosses that said, you need to go do something different. So we're going to talk about where they are today, and I can absolutely guarantee you their bosses are going to tell them at some point, you need to do something different to well-round your character as an Air Force officer and as a judge advocate. So with that in mind, Joe, would you tell them a little bit about how you came in and where you are now?
Yes, sir. So how I came in, I was a
a 2L with a clerkship in New York, thinking that we're just going to live that life. I took a good look around and realized it just wasn't me. So I tried to find something that fit my personality a little bit better. Whether or not I made the right decision. Anyway, but I chose the United States Marine Corps because they have great marketing. Their uniforms are obviously the best. And I'm just a sucker for that kind of thing. So I decided to turn down my law firm job in New York and join the Marine Corps. I was, my first big Marine Corps has found out about some of my comments already. So I went in the Marine Corps. I was a defense counsel at Camp Pendleton in San Diego, which is just about the best place to be stationed in the world. I did that for about 2 years. I deployed to Guantanamo Bay for 6 months, which in the Marine Corps is a reward. We reward people with deployments. I know it sounds like punishment. I spent 6 months down there doing military commissions work. I came back and I was a prosecutor, and then I got picked up to go to the Pentagon, which again also sounds like punishment if you've worked at the Pentagon, to work at Headquarters Marine Corps. I spent a year training prosecutors out of Headquarters Marine Corps, and then I wrote doctrine, which is a meaningless thing to anyone that's not in the military. Then I, again, got rewarded, I swear, with a deployment to Romania with a Marine Infantry Battalion. I came back, got off active duty. I joined the FBI for a few years, and I've stayed in the reserves since I got off active duty in 2017. And now I'm a civil litigation attorney in St. Louis. And my current assignment is Deputy Staff Judge Advocate for 4th Marine Division down in New Orleans.
So how long have you been on active duty?
I was on active duty from 2011 through 2017,
Okay.
and then I've been in the reserves since then.
And how long on the reserves?
Shoot, 4 years or so.
Yeah, I think one of the important things to note here is the reserves feed off normally the active duty that are leaving active duty. And the attraction is you can stay in uniform and continue to serve, even though you want to perhaps go off and do something different. So,
yes, sir.
And that's great. The young judge advocates in the Air Force that we recruited, we always told them that if this isn't for you full-time for the next 20 to 30 years, think about the reserves or think about the Guard. Missouri Guard is a terrific unit. So and there are several Guard units that are wonderful. Alaska Guard, all the states are great, but some of them just are a little better than others. So, okay, thanks, Joe. Larissa, tell us a little about your background.
Sure. So I was interested in being a JAG even before I came to law school. But while I was in law school, my second year, I landed an internship with the Coast Guard down in New Orleans, which was wonderful. I spent a summer there in their legal office in the District 8. Really loved it, and I decided that was it for me. That was the service I was going to join. I really liked the people and the work and the missions that we do. I applied in my 3L year and magically got it. I was told many times that no one gets it their first time, but I did. And right now I'm stationed in Norfolk, Virginia in command services. So I advise about 8 or 9 commands on a whole host of different issues all across the eastern seaboard.
Good. Linda and I are real familiar with Norfolk. Our daughter went to school down there, so very good, very good. Janelle, why don't you tell us a little about your background?
Yes, sir. So I graduated from Mizzou with these guys in 2019 and direct commission into the JAG Corps, the Army JAG Corps in January of 2020. From there, went to Joint Base Lewis McChord, which is a Joint Air Force Army base. And for my first billet, I was an administrative law and national security law attorney, and also a part-time military magistrate. So I kind of wore 3 different hats during that first assignment. And I'm still at Joint Base Lewis McChord, but just moved to a military justice advisor position where I primarily advise company, battalion, and brigade commanders on military justice issues. So mostly they call me on Monday morning and tell me what their soldiers did during the weekend and ask for advice about the trouble they got into.
Yep.
That's really it, sir.
Well, tell us a little bit about being a military magistrate. What are the duties there?
Yes, sir. So it's a quasi-judicial role. Basically, you sign off on search authorizations and also conduct pretrial confinement hearings. It's it's a really fun experience. I advise anyone who has the opportunity to do military magistrate work to do it, even though you're on call, and it can be, it's definitely an extra duty, but it's very interesting work.
Yeah. The Air Force has a different model. Our magistrates are normally deputy base commanders, but on the phone is a judge advocate. So and Linda can attest to this, for 2 years, I was awakened every Friday and Saturday night with another probable cause question. And, but that's part of the fun. When you're younger, it works out fine. All right, very good. David, could you tell us about what you do?
Yes, sir. So Captain David Rogers, stationed at Fairchild Air Force Base in Washington State, home of the Air Force's largest refueling wing and the Survival Evasion Resistance Escape School. In my capacity there, I'm currently sitting as the Chief of Adverse Actions, so any administrative actions up to court-martial. Court-martials are an additional duty that I do as well. I've done litigated courts, plea agreements in all types of forms under the military justice section. Prior to that, I was Chief of Operational Law and International Law and Civil Law as well, so well-rounded experience. Pops did 42 years in the Army, so serving was naturally something that I wanted to do. I picked the Air Force because I still remember being on my bike when the B-2s flew over Warrensburg to go respond to the 9/11 attacks. And so I said, if I decide to join, that's the branch that I will join. And now I'm here.
Fun fact on the Surrey School, Survival and Escape School, and you guys weren't on active duty when this occurred, but waterboarding was one of the things that they did there to make sure that the pilots were capable of resisting. So when the Department of Justice came out with their opinion that said waterboarding is okay, it was a couple of those guys out of the Surrey School that helped them. Later, Congress, led by Senator McCain, said no, waterboarding is torture, and today we don't do that anymore. But the bad guys do it, so it's important for our guys to be ready to resist. All right, guys, that's terrific introduction to all of you. Let me start with kind of the fields of practice. And one of the big fields of practice we have, and most judge advocates start in some sense in this area, is military justice. So I'd like to talk about military justice.
We have one more jag that just joined.
Oh, I'm sorry. Hey, Captain, how are you?
Hello, sir. I'm doing good. How about yourself? Sir, I think I lost audio, sir.
Or in uniform. Are you involved in military justice or something else?
Okay, I'm back on, sir. So I'm currently assigned to the 1st Armored Division in Fort Bliss, and I am an administrative law attorney. Unfortunately, I wasn't able to be in person. Fort Bliss was one of the locations that was chosen for Operation Allies Welcome, and so we've been very busy in the ad law shop team and all across. And so I can talk a little bit about what that operation has been and also what my job in the administrative law team has been so far. And also, as a general background for my JAG experience. So prior to joining the Army JAG Corps, I was in the Texas Army National Guard, which I would argue, sir, is one of the better states as well. And so in that capacity, I served in the Field Artillery Branch and the Adjutant General Branch.
What I do now, again, is to turn to fields of practice. Most of the JAG Corps view military justice as the bread and butter of what we do. In other words, we build on that experience in the courtroom. Military justice is just a species of federal practice. If you remember your constitutional law, the first article of the Constitution deals with Congress. And Congress has the authority to regulate the armed forces. And part of that authority is to create some kind of a code of military justice. So military justice doesn't spring from Article 2 and the President's authority, although the president is kind of accountable for implementing it, but rather springs from the Congress. And since 1776, General Tudor was the first Judge Advocate General of the Army at that time. We didn't have an Air Force. We frankly didn't even have a Navy at that point. We didn't have a Marine Corps. You know, he was the Judge Advocate General of the Army, our first one. And he implemented something called the Law of War. We had a Law of War until 1950 when they changed the name to the Uniform Code of Military Justice. And that's what we have today. So all the substantive crimes are defined in the UCMJ, as well as all the rules of evidence and the procedural rules are all defined there. So I'd like to ask all the panel participants, you know, what experience have you had in the UCMJ and prosecution?
Excuse me, General. To accommodate Captain Taryn, who we definitely want to hear from, the audio crew has asked that you each hold up a finger when you're getting ready to talk.
Okay.
Because they have to deal with feedback. So if you're going to talk, show them your finger. Yeah.
This finger.
Yeah, show them the right finger. Okay, so let's begin at the end of the table again.
Yes, sir. As I mentioned, my first billet, which is what we call assignments, was as a defense counsel. I served in that capacity for about 2 years, and then came back and worked as a prosecutor. Like I said, they actually deployed me between those two periods because, if any of you have ever served on one side of the aisle or the other, you can imagine I don't want to say animosity, might not be the nicest way to put it, but how difficult it would be to just flip that switch from being a defense attorney and then go be a prosecutor, working with the same commanders that you've most likely upset as a defense attorney. You're now supposed to give them advice on what to do. So they try and space that out a little bit to give everyone a cooling off period.
Yeah,
but
good.
But yeah, so after that, then like I said, I went to prosecutor training in the Pentagon.
Yeah, the Air Force example is once you're a defense counsel and you leave that role, you're going to another base.
Yeah.
Because that's what happens, yeah.
Yes, sir.
You didn't make great friends when you were a defense counsel. So that's good. I know the Marine example, and you guys do a lot more special courts, which is the lower level court, kind of the misdemeanor court for the UCMJ than any of the other services. Okay, how about you?
So I advise on investigations of UCMJ violations in my role. It's before the case is referred or preferred to a court-martial. I advise the commands on the investigation part of it, and then we'll refer it to the trial services afterwards for.
So why don't you explain what referral and pre-referral and referral are all about?
Yeah, sure. Yeah, so I get a call, like Janelle mentioned, from a command that someone has done something that they shouldn't have. We launch an investigation. We get that report back. Coast Guard Investigation Services also does that as well. We look at it, determine whether or not there's any substance to the allegations, and then I'll kick it over to trial shop, and they will do a referral and referral. Referral is that there are charges, and then referral is to an actual convening authority to go forward.
Yeah, and those are different commanders that make those decisions. Yes. So typically, the referral authority that makes the final decision to go to court, what rank would that person be?
Usually an admiral.
An admiral, okay. 07.
Yes, sir.
Pretty high up there. Okay. Captain Murphy, what do you think on military justice?
Yes, sir. So my role is very similar to Lieutenant Tiller's. I primarily advise commanders on the UCMJ, also talk to CID and MPs about what can potentially be charged. I work pretty closely with trial counsel on, just talking about the facts of the case, what kind of proof we have, if it's advisable to even charge the case. So I don't really spend as much time in the courtroom. I do second chair guilty pleas. I do also administrative separation boards, okay. Which is more of an administrative function, as you know, sir. And that's primarily it.
So on an administrative separation board, the conclusion of the board might be honorable discharge or a general discharge or an other than honorable conditions discharge. Is that correct?
Correct, sir.
Okay. And those are pretty significant because those define what your benefits might be.
Yes, sir.
So if you're talking about, airmen and soldiers, sailors, and Marines that are after some kind of a benefit, medical benefit, it might be difficult if you had that last one, the UOTHC. So
Yes, sir.
good, good. All right.
All right, excuse me, y'all need to speak up.
All right, Captain. Yeah. We're Air Force, we always speak loudly. May not be appreciated. All right.
In my capacity, and for the students that are watching, and one of the biggest reasons why I chose to join the Air Force is the Air Force prioritizes litigation, right? So if you're assigned to a legal office base, court-martials are considered an additional duty, and that is welcomed. So I've actually handled courts by myself. Usually there is, if it's what's called a general court-martial, which think of that as your felony docket, you'll have a senior trial counsel that is a detail to that case as well. But I've gone on through those, as well as special court-martials, which are kind of your lower level felonies, and then your summary court-martials, which are misdemeanors. And really misdemeanors can go into the special court-martial context as well. I've done those by myself as well. So in addition to advising command on how to move forward with courses of action, also doing court-martials as well.
Good, good. All right, on our video, our Army captain, what do you think about this topic?
Sir, so I'm currently assigned as a military magistrate for Fort Bliss, and so my role within that organization is to advise CID and either deny or approve their search warrants. In addition to that, I do pretrial confinement hearings, and so my involvement with UCMJ is limited to those two actions.
CID is a Criminal Investigation Division. Different services have different kind of felony investigators. NCIS for the Navy, OSI, Air Force Office of Special Investigations for the Air Force. In the Air Force, we don't have a TV show, so we have to kind of announce that on our own. Well, thank you. All right, a thought for all of you. Recently, the UCMJ has come under attack in Congress. Senator Kirsten Gillibrand from New York, that took Hillary Clinton's position in the Senate, believes that the reason we have a large number of sexual assaults in the military is because commanders determine whether or not those things go to trial. And if the commanders weren't in charge, more would go to trial. I can't disagree more with her. And she has no experience in uniform. The fact of the matter is they're kind of comparing apples to oranges. They look at all of our claimed sexual assaults, and we have anonymous surveys in the services. And we know 87% of sexual assaults are never reported to the commanders. But we're accountable for why those didn't go to trial. In the civil sector, in the civilian sector, you only know about those survivors that filed a complaint. So to compare the two, it's really an inequity. She wanted the UCMJ drastically changed and pull the commanders out of their gatekeeping role that you heard about today. So she put the bill together, the Military Justice Improvement Act. And if you know anything about Senate procedures, and if you listen to the news, you're probably learning a lot right now about that, is that, a filibuster can be filed by anyone. Now, years ago, a filibuster required that somebody stand at the podium and talk forever, read the phone book, or whatever they wanted to do. Today, all it takes is a phone call that says, I want a filibuster. Once you have the filibuster called, then it requires 60 votes to pass legislation. At that point, with 60, that's called cloture, and it ends a filibuster. On the Military Justice Improvement Act, Senator Gillibrand and her allies got to 55. They were 5 away from ending the UCMJ. And it's going to be reattacked. It's under attack again. And the difficulty we have is trying to explain why commanders are in this process. And maybe that's something you ought to think about as well. Commanders are in this process because we win and fight wars, because we bring 4 things. You know, the best people, the best training, the best equipment, but the 4th leg of that stool is military discipline. And a commander has UCMJ authority to ensure that his troops are disciplined, and not that somebody else is ensuring that. And if every airmen, soldiers, sailors, Marines know that they're accountable 24/7 to that commander, then you wind up with a better behaving force, a more highly disciplined force, and a more combat effective force. So that's why we've got that, and you ought to keep your eye on that. You're going to see this in the news again in the not too distant future. So we talked about military justice. That's great. There are other fields of practice that we ought to also talk about. And every military installation is like a small city. All right, if you've ever been on one, if you go to Whiteman, you'll notice this. They have every issue that a small city would have. They have environmental concerns, they have contract concerns, they have labor or employment law concerns. They certainly have military justice concerns that we talked about. There are a lot of different things. And the judge advocates that are assigned to those bases are required to kind of be jacks of all trade. They need to know all of that. And oftentimes when you're more junior, you don't know that. So you got to get up on the learning curve pretty quickly. So that's what I'd like to talk about is other fields of practice. I'll give you a couple of, legal assistance is one, certainly with, you have the first time the client has a face is in legal assistance. And you're required to maintain confidentiality and zealous representation for your legal assistance client. Environmental law, we talked about, employment law, admin law, which is administrative law, very important. Contract law, logistics law. Yours truly actually practice in space law, but the other services don't do that. And I knew nothing about space law when I got that job. Real estate law and utilities law. Those are all things that a city has to deal with, except space law, that these guys have to deal with. So I'd like to ask, and again at the end of the table, so Joe, what non-military justice functions do you perform?
Me specifically or the Marine Corps in general, sir?
Well, both actually, but okay. You specifically first.
So outside of military justice, the only other practice area that I was really involved in was operational law.
Good. And define what operational law means.
Put me on the spot. The law of operations. No. So essentially, when you're getting ready to deploy, you're thinking about who is my client, and your client's usually a commander maybe in a combat zone, right? Who has to make decisions about, can I put people in this place? Can I use this kind of weapon? Can I, use money from this pot to pay for this thing? Can I give a gift to one of our training partners, right? So operational law encompasses a lot of subsets of like ethics, right? You're like, well, how can I spend this money on this thing, right? Which is an innumerable amount of work comes into pots of money and what you can spend it on. And so we did some of that in particular, and then, one of my deployments was supposed to be to Saudi Arabia to do a targeting mission in Yemen. And so, you learn a lot about the law of targeting, right? Which is, again, you're looking at Geneva Conventions and what kinds of ballistics you're allowed to use, and then the effects of those ballistics, and certain flight patterns of different weapons and the effects that those weapons have when they make contact with certain types of buildings and things of that nature. So it really is a varied practice area, and it's very particular to where you're going and what the commander's mission is, because you have to be familiar with what they're going to do so that you can advise them that everything they're doing is above board.
So when it comes to targeting, we're really talking about a species of international law.
Yes, sir.
Yeah. And it's all defined in international law. It goes back 2,000 years. And to really do this well, you have to be well schooled in that. So what is the military necessity? What is the positive identification of the target? What is the collateral damage? Is it excessive to the military necessity part of this program? And JAGs are in that process. And you talked about air, and Marine air certainly. But we've got an air operations center in the Middle East that deals with this every day of the week. So you need to be Johnny on the spot. And you can't say, I got to call a friend. I mean, you got the bad guy's there right now, and you need to deal with that. So that's not only exciting, but a little stressful as well. Okay, what about the Coast Guard?
All right, so I deal with anything and everything. I'm the command advisor to a whole bunch of commands, and they call me every day with all sorts of issues, from employment law issues to ethics, like we talked about military justice, I review contracts. I am their general law practitioner any day of the week.
Yeah, that's great. That's great. And again, in the future, those challenges will just be added on. I mean, it's like a mountain of stuff that you're required to know. In 34 years, I think I touched base with all of them, but it wasn't always painless. So, okay. How about the Army, Captain Murphy?
Sir, outside of military justice, I've practiced administrative law and operational law like Major Neely. For operational law, mostly I would sit in on what's called the military decision-making process. So I would be the only attorney in the room, usually advising, but I was also tasked with drafting your rules of engagement and other components of the legal annex, doing some international law, also researching particular laws of the countries that we were performing an exercise in. For example, since I am at JBLM, the Pacific is our area of responsibility. So a lot of those countries in Asia still practice Sharia law, so that's something that I have to make commanders aware of, and soldiers should be aware of as well. That is, operational law is really fun. It's very interesting. All kinds of things come up. Administrative law, not as exciting. Primarily, I would work through religious accommodation requests, review line of duty investigations. So if someone is seriously injured or dies, there has to be line of duty investigation. In the Army, we also have 15-6s, which are other administrative investigations anytime a big piece of property is destroyed or lost, or there's some sort of misconduct that doesn't rise to the level of criminal misconduct. That gets investigated. So a whole host of issues, sir.
And one of those administrative law issues is the Freedom of Information Act and,
yes, sir.
and Privacy Act, so, which is bread and butter to our practice. And you kind of wind up memorizing every exception under FOIA, Freedom of Information Act, known to man. So, okay, great. Captain Rogers, what do you think?
Yeah. So TJAG, the Air Force's current position, right, is to divide the Air Force into 3 legal domains in accordance with the NDAA, right? So operations and international law, civil law, and military justice. I practice in all 3 areas. We've hit ops pretty extensive, so I'll focus on civil law. For Fairchild, right, we operate in a lot of different areas, and so sometimes it's as simple as making sure that we have memorandums of understanding or memorandums of accounting in place with local law enforcement or with the Department of Resources and Natural Resources so that our operators can operate within those areas. There's a lot of environmental issues that go on at Fairchild Air Force Base. It's one of the most green bases in the Air Force. And just briefly on the legal assistance, right? I think one thing that I did not know when I came into the JAG Corps, right, is legal counsel, right? Part of that is counselor, right? So a lot of what JAGs do, especially on their first rotation, is to counsel those people that really need help. And it's really empowering as a JAG to be able to help that airman that's having trouble with their rent, or that airman that's having trouble understanding a process because it's way above their head. Counseling people and using the skills that we learn in the Veterans Clinic on how to proceed with what the best course of action is going to be for their family and how this process works. So I guess that's what I have to say about the civil law domain, sir.
Sounds like all you guys are right on track. And online?
Sir, just like Captain Murphy, my involvement with the administrative law team is from investigations, advising, doing legal reviews, FOIA requests. I mean, it's a lot of information and a lot of work. And something that I'll touch in addition to what Captain Murphy already said is, with the Operation Allies Welcome, we're working with our interagency partners to ensure that Afghan guests are processed expeditiously. And what that means is, standing up sort of from the bottom up, every sort of tent and facility that you can think of to house approximately 10,000 Afghan guests here at Fort Bliss. And so with that being said, there's a lot of contract issues that are involved. There's a lot of environmental law issues. And so working through those and ensuring that we're doing everything that we can, both legally and ethically, has been my involvement so far. And so I've been very fortunate, right? I wasn't expecting this 3 months into the JAG Corps, but this is what the Army does. So we'll just get ready to employ.
Just a short story on operations law. When I was at Offutt Air Force Base, we were tasked with supporting the Air Operations Center. In other words, we were doing targeting in Afghanistan. I've been to Afghanistan 4 times. And so we were practicing the targeting part. We had imagery from the Predator, a drone, would fly over and take pictures of what was going on. And there was this one village where all the crops were green, but there were no people in the fields. There was, however, a dog in the fields. And our belief was all the people knew when the Predator was coming over because you could hear it. So they'd all run and hide in these caves. So the operators wanted to seal the caves, meaning put a bomb on the top of the cave and let it collapse. And of course, you have to have military necessity. So the question that we asked was, where's the military necessity? And they didn't answer that. And if you know anything about Afghanistan, if you're going to be married, sometimes you have to bring something to the marriage, and a cave is a great place to live. It's cool in the summer, it's warm in the winter, and so a lot of those caves are occupied by civilians. So we said, no, we don't recommend you do that. The next day, 24 hours later, the same image comes up. The fields, the dog in the field. And again, I said, is there some additional information here? Oh, yes, sir. General Franks says seal all the caves, and we're going to move everybody east to west. And I knew that wasn't true. And I said, I will call General Franks' staff and talk to them. Well, they didn't want me to do that, but I was going to, and I did do it. So we dropped that discussion. 24 hours later, the same image comes up in the conference, the dog in the field. And I said, I was getting a little irritated. Is there new information here? And they said, yes, sir, there is. And then this disembodied voice, and I won't tell you which agency it came from, but said, yes, we're real certain with our human intelligence that the Afghans have military supplies in those caves. So I said, why didn't you tell me that from the get-go, from the outset? And they said, well, we didn't, so we're sorry. And I wanted to be complimentary of them because they have geologists that know everything about those caves. They know how deep they are, what the rubble is outside, and therefore how far back the caves go. So I said, you guys are awesome. You have all the science under control here. I bet you know everything. I bet you even know what that dog is in the fields. And without missing a beat, they said, yes, sir, it's an Afghan. So, touche. All right, you guys are awesome. But that's the kind of thing we wind up doing in operational law. All right, I want to talk about ethics. All of us have done legal assistance before, where you can kind of identify your client has a face, right? And the Code of Professional Responsibility, every state has a Code of Professional Responsibility based on the Uniform Code. It's real important to follow this. If you don't, disciplinary action can be incurred by your state licensing authority against you, to include, in the extreme, disbarment. So it's real important that you be able to identify who is the client. A lot of the issues that we talked about, you're talking to a commander. But the commander's not the client, because the Code of Professional Responsibility says the institution is the client. So the Air Force, the Coast Guard, the Marines, that's your client. Doesn't have a face, but that's where your duty of zealous representation and confidentiality is really owed. That's not to say that you run around and blab about everything that you told your commander, but if you were asked and forced, you would have to. There are other areas where you have the client has a face. Defense counsel, the client has a face. Something, the new kid on the block that went into action right before I retired is the Special Victims Counsel, representing victims of sexual assault, survivors of sexual assault. That's your client. You don't have another one. If you want to get crossways with a TJAG, think that you have another client other than that, because I would not tolerate, anything that suggests that you didn't zealously represent your client. But in all other cases, it's the institution. So I want to ask, have you all ever had a difficulty in this area? And if so, what might it have been? We'll start with the Marines.
Thank you, sir. You already kind of pointed out, I think, the most difficult time I've had with an issue like that is being a defense counsel. And it's probably the most rewarding job I've had in the Marine Corps for that reason, because you do have a client, you have some 19-year-old kid who left his friends and family and decided to join the Marine Corps of all branches during a time of war. And so, you're and then regardless of what they've done, right, there's always something good there, right? So you can always fall back on, man, this is probably a good kid who either made a bad decision or is being wrongly accused. And, that's it. You're the only person, you're their lifeline at that point. And so you're doing everything you can to take care of that kid, whose family is probably 1,000 miles away, and whose command has said, get this Marine out of here. He tested positive for THC on a drug test. Like, I don't want him in my unit. Get him out of the Marine Corps. And so, and maybe this kid still wants to, maybe they made a mistake, maybe they want to stay in, things like that. So, I guess to more directly answer your question, you're fighting against what a commander wants, right? And in the Marine Corps, commanders are sacred and sacked. I mean, that is who runs the show. We are a war-fighting institution, and commanders have a ton of authority to make sure that we can fight wars. And so you as a defense counsel are basically telling the commander that he's wrong, and that what his recommendation is bad. And that does not sit well with some Marine colonels and lieutenant colonels, as maybe you can imagine.
Yep.
But again, you have a duty to zealously represent your client wherever that takes you. And sometimes it takes you to getting chewed out by a lot of other people, but it's worth it.
Yeah. We all get kind of a wire brushed every once in a while, get chewed out. And if it gets real bad, though, the Judge Advocate General has assignment authority. And you're going to go someplace else where that won't happen. All right, very good. Lieutenant Tiller, what do you think?
So from a legal assistance perspective, I don't really represent members very much or anything like that. I have had the opportunity. Yes, ma'am. I have had the opportunity to represent someone before an administrative separations board, and that was a contentious process and one that I got to see a different side of things. I'm normally the one advising a command on separating someone, and this time I was representing the member who was getting kicked out, and that really changed my perspective on the whole situation. I talked to him and his wife about what that was like for them, and that really was eye-opening. And then we also deploy in response to hurricanes. So after a hurricane goes through an area, we send out legal assistance attorneys to the area to help Coast Guard members in the affected AOR. And I had the opportunity to do that one year as well, and that was great to have face-to-face interactions with those individuals after something really horrific had happened to them and be able to provide that assistance. It's been really rewarding.
That's great, yeah. All right, Captain Murphy.
Sir, I haven't had a lot of ethical issues, but Major Neely did touch on this briefly earlier. When you have to tell a commander no, that's always a sticky situation. So I guess the advice I've received from smarter and more experienced attorneys is you don't tell a commander that he can't do something, even if it is the law. You tell them, here are your options, here are your different COAs, courses of action, but this COA has a lot more high risk than this COA. And it's your decision, sir. And I always make sure that I have plenty of top cover so that my boss knows exactly what advice I gave, and let him know whether the commander followed that advice or decided to use the high-risk COA.
Yeah, I worked for a commander in Alaska that he was very concerned about the minute-and-a-half message. So you had 90 seconds to make your case for whatever you wanted to do. And sometimes these cases are more complicated than 90 seconds. And I recall one time I was talking to him, and he said, "Stop, here's my decision." And he and I stared at each other in the face, and I raised my eyebrows, and he said, "What?" And I said, "Well, that would not have been the decision I would have made." And he said, "Well, why?" "Because you don't have all the facts." And that was fortunately the last time we had a 90-second conversation, but it happens. All right, Captain Rogers.
I think for me personally, my most conflicting times as a JAG is when I'm in that courtroom or that administrative separation board, because my client is the Air Force, but I know the practical effect of what a bad conduct discharge or a UOTHC is going to do to that member. And I learned those through the clinic. So it's hard to argue for that, but at the end of the day, you have to zealously advocate for the interests of the Air Force. But I will be honest, there have been times where I've alerted the defense to the Hagel and Carter memo for that discharge characterization upgrade. So that's where I see the most conflict for me personally.
Very good, very good. All right, what about the rest of the Army? How do you feel?
So I'll just touch briefly on what Captain Murphy already said, and that's, we have our technical chain of command, and then we have our regular chain of command, which is, our commander, our battery commanders, our troop commanders. And so whenever, I haven't personally encountered this issue, but I know that whenever I have a question or an answer that perhaps is not that suitable for that commander, I reach out through the technical chain and ensure that everyone in that technical chain knows what's going on and have the facts in order to advise as that escalation occurs.
Very good. All the Judge Advocate Generals, otherwise known as TJAGs, fly top cover on this issue for the rest of the JAG Corps. So there's a couple of occasions where I was asked by the general officer staff, Harding, you have too many acquittals. And I said, well, thank God for that, because it builds credibility. We have a burden of proof beyond a reasonable doubt, and when it's not there, it's not there. And a lot of our cases are 1v1. He said, she said, particularly in sexual assault. And if there's reasonable doubt on what the survivor's story is, then they are obligated by law to acquit. So I had to, kind of protect our folks because, frankly, as is true downtown, in the civil sector, 50% of those cases result in acquittal. That's okay. As a matter of fact, that's the way it's probably supposed to be. So it's awfully important to fly top cover for those folks. Same thing with the Special Victims Council. All right, Harding, your Special Victims Council are advising victims that they can prefer charges. In other words, start the charging process on their own. Yes, they are. They're told that. We don't like that. I'm sorry, but that's the law. And well, we don't want your Special Victims Council telling them that. I will not do that. They're going to represent their clients zealously. I'm not going to slow them down. That's what TJAGs do to protect the guys in the field. Okay. Here's an easy pop-up question for all of you. What's the accomplishment you're most proud of in your service thus far? I'm going to start with the Marines again. You had a real curious look on your face, but.
That seems like it should be a lot easier question. Most proud of accomplishment. Maybe, I don't know if I would point to one thing specifically, but the fact that I've had parents of Marines that I've represented as a defense counsel come to me and thank me for saving their kids' lives, right? Which is obviously an exaggeration, right? They're potentially just going to jail. But to say, like, thank you so much for taking care of my son. He, called me, told me all about you and the work that you're trying to do, how he feels like you're the only one that listens to him and the only person that goes to bat for him. There's been a handful of times where somebody from Wounded Warrior Battalion, which is where we send people that are maybe injured while on active duty to try and recover, maybe as they get processed out, that are going through court martials because they've got other issues, right? Maybe you're suffering from PTSD and you have a problem being on time to get to where you're supposed to go. And in the civilian world, right, if you're late for work, you don't go to jail. The Marine Corps, you very well may. But anyway, just the opportunity to take care of Marines is by far the most rewarding part of the job.
Yep.
Sure.
That offense is called the offense of failure to go to work on time. I was briefing a hospital squadron, they didn't get it. And one of the hands were raised and they said, failure to go, that's just not a problem, we catheterize the patient. And I said, that's not what we're talking about. So we need to start with real basics. So failure to go is probably the #1 UCMJ offense, minor offense, that occurs in all services. All right, how does the Coast Guard feel?
All right, most proud of, that's really hard actually. In general, just surviving every day, it presents new challenges, and I've gotten through all of them. And also, I've been told that I have a great ability to do what's called Roger up. So something pops up one day, you have no training in it, no idea what the hell someone's asked you to do, and you just go to someone, get real quick, how do I do this? What do I do? What manual should I read? I can dive into it and do that. And so far, I'm pretty proud of that ability. But as far as like representing someone, my ad sep didn't go very well, and my member didn't get the result I preferred. But he did call me afterwards to thank me for listening to him, because he felt like he was getting railroaded by the command and everyone in it, and he really appreciated me just talking to him and his wife about not just the process, but about what was going on in their life, what their plans were afterwards. And he said it made him feel like he was cared about within the system. So.
Okay, terrific,
Yeah.
terrific. Captain Burke?
I don't know about my most accomplished moment, but I can share a short story about a rewarding moment for me. I was advising a victim of a forcible rape about this soldier. We do have to notify the victim whenever the soldier is about to get separated. So previously, the victim decided that she did not want to testify, which is completely fine, but it was a he said, she said case, and without her testimony, we couldn't go forward to court-martial. Some time passed. The command, for whatever reason, did not want to separate this soldier. And so I was explaining to her what the administrative process looked like, what did an administrative board meant, what the difference was between that and a court-martial, and just explaining to her what would be the result for this soldier. And the government, meaning me, we're looking for an OTH, which is an other than honorable discharge, which is the worst discharge you can get in an administrative separation board. You can only get a dishonorable or bad conduct discharge if you go to court-martial. So I was explaining those things to her, and she said, so it's basically just a firing? And I explained, yes, he would lose a lot of his benefits, but essentially it was just a firing. And she kept repeating over and over, I just don't feel like that's enough. I don't think that's enough. And so in the end, she did decide to testify at court-martial, and we are going to prefer charges for a forcible rape, essentially. And I just felt like I did a very small part in empowering her with the information so that she could make the decision that she wanted.
A lot of survivors elect not to go to trial. It's not because the offense didn't happen. It's because there's a lot of peer pressure in a lot of these units. So if you want to rip the guts out of a unit, have both an alleged offender and alleged victim in the same unit. And they'll all team up because they're just right out of high school, and they'll decide, do I like him or do I like her? And it's awful for the unit. And sometimes to avoid the peer criticism, a lot of our survivors will elect not to testify. So it's a constant kind of thing, and that's their right to do. We'll defend their right to the end of time to make that election. But once they understand what the consequences are, as was true in your case, sometimes they change their mind. And that's a real indicia of heroism. You know, you're a hero if you do that, because you're going to take on all that criticism from your unit. You're not going to be the most liked person in your unit for some time. One of the things we can do is move you out of that unit, and you can start fresh someplace else. But it is very difficult to do in some of these smaller units. All right, Captain Rogers.
I think for me, there's certainly personal accomplishments that you're proud of, but personally, I think the most thing that I'm proud about, honestly, is when my team succeeds. And that's because like our unit just fires on all cylinders at Fairchild, and it is nice to see that the attorneys aren't always getting all the credit for it, and that those underneath you that you've trained and entrusted are succeeding. And so to get that recognition and see that recognition for those around you and to see the overall unit being lifted up is what keeps me going and is what I'm proud to see.
Terrific. All right, online, what does the rest of the Army feel about this?
So for me specifically is, and I've talked about this before, is Operation Allies Welcome, right? So this is history in the making, and being able to walk out there and along the tents and see children play, for me, that is one of the things that really touches me, and it puts meaning into the things that we do, not only, here with this mission, but all over the world.
I'd like to switch the topics again. This law school does terrific work when it comes to combat disabilities. PTSD, post-traumatic stress disorder, TBI, traumatic brain injury, MST, military sexual trauma. That's what Professor Drake does so very well here. Before they separate, however, all the services have some kind of process that allows them to identify those with disabilities. Sometimes it's very difficult to do that. Now let's talk about airmen, in my case airmen, coming out of Iraq and Afghanistan. What you principally want to do is you want to go home. You want to see your friends, your mom, your dad, your girlfriend, your spouse, and you're pretty sure, because self-hypnotically you've convinced yourself, you're going to be great and fine. You're going to decompress once you get home. Then somebody comes to you and says, are you having difficulty sleeping at night? Do you have anger with your spouse when you're on the phone? They all get on the phone or online. And they know what the right answer is. You want to go home, you better say no. So they say no, and they go home, and they find that they can't cure themselves. And now they're separated, and then they come to Professor Drake's clinic to try to get some relief. But I'd like to talk about those things that we can do while they're still on active duty before they separate. And if they do indicate, hey, I'm suffering, I think, from one of these things, they're not doctors. It's hard to self-diagnose. But you know if you're having difficulty. And some of my people came back from both combat theaters, and I knew they were having difficulties. So we got them services. I just knew this wasn't the same person I sent downrange. This person's changed. And 3 or 4 weeks later, they're still not back on their feet. So there are medical services that are available, but let's talk about that. And why don't we start online this time?
So a lot of the things that I do within the administrative law team is advise on line of duty investigations, right? And as we've mentioned before, those are investigations that occur after a service member dies. And unfortunately, oftentimes that is after they take their own lives. And so from my part, I make sure that when I'm advising the investigating officer, that I let them know is like, hey, this is something that is not this is not an everyday thing. This is difficult. And so if you need help, you can reach out to me, and then we can work this out together, because that can get overwhelming. And so, and unfortunately, we do have a lot of those. So that is my piece in that.
The services before separation can award a medical disability retirement and say you're blank % disabled. Of course, you can contest that later, but at least there's a process before they leave if they can identify with their commanding officer or their OIC, their officer in charge, that they've got some issues and they're unresolved. And I know that's the case with the Army. A good buddy of mine was the Army TJ, is the Army TJ. All right, thanks. Captain Rogers, what do you think?
So I think there's a couple of things to do, and the first thing is to recognize that you have to take steps to break down stigmas and provide resiliency to troops, right? The joke is that the Air Force has nicer facilities and nicer bases than any of the armed services. I can attest to that. That is 100% accurate.
That is true. That's right.
But it goes a long way to say that those facilities help increase morale within the unit, and identifying those individuals that need help and understanding that it's okay to ask for help is important. From the JAG perspective, right, I tell you there are procedures in place where before I can administratively separate somebody or before they can be discharged through a court-martial process, that they're having mandatory counselings with a mental health professional They're given extra steps and extra time and duty to complete medical examinations and TAPS, which is the retirement program, to make sure that they transition into the civilian community appropriately. And then in addition to that, right, just recognizing that there are things that we can do as JAGs for those individuals that have disabilities. The Office of Special Disabilities Council in Houston is a program that the Air Force has, and their sole priority is to represent airmen with disability compensation claims as they're still on the active duty side, so that when they get into the civilian side, it's a little bit easier to process that. So that's what the Air Force is doing. I think that's the right steps.
Good, good. Captain Murphy.
Very similar to what Captain Rogers said. So the Army has a medical evaluation board process and then your physical evaluation board process. And I'm not an expert on this, but we do have JAGs, at least at JBLM, who only do that, who only help people with their physical evaluation boards specifically, especially if soldiers want to contest that. They do have the opportunity to do that before they leave service.
Yep.
And as Captain Rogers was saying, you know, soldiers have to go to mental health appointments and their doctor appointments before they can leave service. So if they can be, I guess, candid during those appointments, then they should be getting the benefits that they are entitled to.
Yeah, as I say, the hard part is convincing them that they can't fix themselves in many
Yes, sir.
cases. So, all right, very good. How does the Coast Guard feel about this?
Yes, sir. Yeah, we essentially do the exact same thing as all the other branches. We have like the medical board process and physical board process. We have JAGs assigned to the individuals to help them through that, answer any questions they have. We also have a really great counseling before someone even is accused of misconduct or has a disability, and I think it's a great service that we have. I always recommend that to my commands when they call me with a member who's dealing with some sort of issue, to have they talk to a counselor or have you given them this number so that they can address any issues before it gets out of control. So,
Good,
yes,
good.
sir.
And the Marines? Joe?
Sir, I think this is an incredibly complex question because, especially for the Marine Corps, because we ingrain in these kids when they go to boot camp that they are warriors. They are invincible. You cannot be kicking indoors in Afghanistan and be afraid, right? So we teach them that they are almost invulnerable, right? So that they can go and do the impossible, right? Then we ask them to come back and tell us how they feel. And my God, you will not find anyone more closed off to that conversation than a 20-year-old Marine who's just come back from deployment where he lost a couple of his buddies.
Yep.
And so we have to balance the need to have and fight and win wars with the reality that it changes these kids. And there is a stigma, right? I mean, good, bad, and different. There is a constant battle to tell these kids that it's okay to come back different and to talk to somebody about it. But it is so hard, and it is a constant fight. And truthfully, I have a friend that's an Army major that is a psychologist that's attached to a special operations Black Hawk unit. And the work that she does for those special operators is unparalleled, right? Because she gets their minds right. And she's trusted. And that's what's so hard. You know, the Marine Corps, we rely on the Navy for all of our medical stuff. And so we don't have that same structure that some of the other branches do to really take care of people. And I think that's my personal opinion, definitely not the Marine Corps' opinion. Crap. But, you know, yeah, that's one of the shortcomings that we have, right? So we are constantly fighting that stigma to treat and then return to combat, right? Because what these kids are deathly afraid of is getting sent home, getting pulled out of their unit because they're having a tough time. And there's nothing more important to them than deploying again with their brothers and sisters, right? And if you tell them, hey, if you tell me that you're suffering from PTSD, you're not gonna go back to Afghanistan. They will never talk to you. And it's just a constant fight. You know, we really have to balance that line. and it's hard.
Yeah, I recall one of my sergeants I sent to Afghanistan, he was a court reporter. And he was over there to do 15-6 investigations or whatever that, you know, the investigative agencies wanted, and either summarize or verbatim, you know, the testimony. So he had terrific language skills. They didn't currently have any investigations, so the commander that he was working for, attached to, said, I want you to be a convoy driver. So he wound up driving a truck on his 125th convoy. The lead truck, he was in number 2, the lead truck had an IED, improvised explosive device. Those soldiers were killed. He was lifted into the air about 30 yards and slammed to the ground. He doesn't remember what happened next. What happened, according to all the testimonies, he got out of his vehicle because training kicks in, assumed a combative stance on the knee, and fired into the brush line because they were taking small arms fire from the brush line. Others got out of their vehicles and joined him. I didn't know about this until his wife called me. His wife said, something's wrong with my husband. And I said, what? And she said, he can't remember if he had breakfast by the time he goes to lunch. And if he did, what he might have had. He continues to drive in the convoy, but he can't remember where he's going. So he's real reluctant to be the lead vehicle, so he can just follow. And hopefully all this will work out. And he sends me these crazy emails that don't have a complete sentence in them. And I've said, well, would you mind sharing one with me? And she did, and they didn't make sense. Talk about reverie. There was no logic in any of this. So I called my sergeant. And I said, you know, there's something called traumatic brain injury. And I want to check you out. Oh, no, sir, I'll be fine in a couple of days. And that's the mentality. I'm going to get back in the truck, and I'm going to be a convoy driver. I said, no, you're not. And I will talk to your commander. You're going to go to the hospital. I called the commander. We don't have that kind of field service down here. They were real close to the border of Pakistan. I said, well, they do up in Kabul, and I want them to go to Kabul. You want me to send somebody else, fine, but this one's going to Kabul. And to this day, he has TBI. And he got, from what I understand, 100% disability as a result of what we did in the Air Force before he separated. But I had to really talk loud and hard to convince him that was the right thing to do. And he wouldn't accept the medal. He said, sir, I didn't do any of that. And I said, I've got a dozen witnesses that saw you did that. And the fact that you don't remember it is consistent with TBI. So, and I asked him as a favor to me, would you please accept the medal? And he did. So that's how these things work. And as Joe indicated, it's very difficult to deal with these even on active duty, even more difficult later when they separate and the evidence trail is someplace else. So, but that's what this law school does a great job dealing with. I want to switch gears to something entirely different. You know, I gave a lot of speeches in the Air Force about spouses serve also. So military members might serve, but their spouses serve as long. And I brag a lot about Lyndon, I'm sorry. But she came on in the Air Force the same time I did. So she served 34 years as well. But they don't get ribbons, they don't get medals. They have to do very difficult things. They move quite a lot. Linda's, I think, licensed in 8 states to teach. Well, how did that happen? Well, because we kept moving. So it takes a little bit of on for the spouses to be able to support this. The Army's got a great phrase, recruit the soldier, retain the family. Boy, there's a lot of truth in that. And that's what we all try to do. So I want to talk about spouses or significant others and how they can get through this experience. Let's start with Joe, with the Marines first.
I'm smiling because my spouse is watching this live stream. And I told her that this question was going to get asked, and her answer was they should just pay you more.
That's right.
I don't, so good answer, Maria. You know, the Marine Corps' focus is the mission. And part of the subset, right, maybe 1B, is taking care of Marines. But mission is probably 1A of that. So it's very difficult to have a family or to start a family, especially with a spouse that has their own career and be on active duty. I mean, there are plenty of people that do it and do it very well who have beautiful families and great jobs, and everyone manages. I didn't personally think I could do that, so that's part of the reason I left active duty. The Marine Corps is an expeditionary force by nature, so if you're at a base for more than 3 years, you have overstayed your welcome. We don't do extensions by exception. So, like I said, I was on active duty for 6 years, and I lived in Virginia, Rhode Island, California, Cuba, California again, Virginia, North Carolina, Romania, North Carolina, Virginia, all in a span of 6 years. And so I just wasn't prepared to drag someone around the world with me. I just don't think I'm worth it. She would probably agree. And it worked out. I have 2 great kids. But anyway, yeah. So I'm not sure what the answer is, but I don't have it.
Lieutenant Tiller?
Yes, so my significant other, boyfriend, and I met here in law school, actually, first year. I sat right where Professor Drake is, and he sat in the row right behind me. We were also in the same veterans clinic and in the same semester. And he very graciously agreed to follow me wherever I go. And so that's really been how we've been able to handle that, is he goes where I go, and he's pretty flexible on jobs and what he does. It doesn't seem to matter to him as much, but we're early on, don't have kids, anything like that, so I imagine that won't be much more difficult as the years go on. Coast Guard is a little better than the Marines, though, for JAGs especially. It's usually a 3 or 4 year tour at each billet, so you're not moving around just every whip stitch, but that is something to consider. And then we do have a lot of jobs in the DC area and the Norfolk area and Alameda area. So some JAGs have made it to where they've stayed in the same AOR for 10 years with their families. And that is something our service also considers, is we want to retain those people. And if we have the job there for them and their kids can stay in the same school, then we'll do it.
I'm going to ask you a question I do not know the answer, and as a prosecutor, I know never to do this. But does the Coast Guard have any sea duty requirements like the Navy does?
For JAGs?
For
no.
JAGs,
No,
we do have something called an OPFAM, Authorization Familiarization, where you go out for 2 weeks on a cutter to get some sea time.
That's neat.
Yeah.
Yeah, the Navy does have a sea duty requirement. And those legal offices aboard ships are tiny. And it's usually 1 JAG and 1 legal man, a paralegal. Yeah, yeah. But, okay, thank you very much to Captain Murphy.
So I'm a military brat. My dad was a Marine Corps officer, and one of the reasons, same as Major Neely, he decided to leave active duty was to spend more time with family. That was just the right choice for my parents. For me, I'm not married, but my partner is in Special Forces, and so juggling 2 careers is difficult, but at the same time, it is a little bit easier since we're both service members. Luckily, the JAG Corps is great, at least the Army JAG Corps is great, because JAGs are needed everywhere, all over the U.S., so I can be moved with my partner if that opportunity comes up.
Yeah, I was the JAG assignments officer for a couple of years, and it was amazing the spouse requirements that had to go along with the JAG requirements. So one was a hostess at a hotel, so I needed to find a city with several hotels for this guy to be assigned. And we found those things. It just took a while. Okay, good. And how about Captain Murphy?
Yeah, so for me, I passed the bar, got married, found out that I was having a kid, got orders, and moved to a new state in a matter of 30 days. So I'm married now. I have a 16-month-old daughter, and it's difficult, right? They serve more than we do, right? We're able to put on blinders and kind of just go with what the mission needs, but it's them that have to find out how to transition. It's them that stays home. It's them that has to find new friends and find a new job. And I will say that one area that I think can expand, right, is the Service Member Civil Relief Act. So there has been steps federally that have allowed spouses to kind of transition with military members a little bit easier. And states have also provided greater protections for military members. So Washington State, for example, allows spouses that are licensed in other states for teaching certificates or mental health or something like that to automatically be licensed in Washington if they're married to an active duty spouse. And so there are some steps that the civilians can take to support the civilian spouses. So to those of you that are listening that are able to do that, please do so, because I can only help as much as I can help within my job, right? But we get these ribbons, right? But if you ask anybody who has the ribbons that are all the way up to the top, what their ribbons are for, they'll tell you missed birthday, missed anniversary, and that is the reality of serving. So.
Very good, very good. How about online, Captain?
So I wouldn't be able to do what I do without my wife, and it goes from the very small to the big stuff, you know, all the way. I mean, she is it, and so yeah, family is the only way that we can serve, because they take everything at home. And so the JAG Corps within the Army has recognized that. And so for students who are thinking about this and who are both attorneys, right, the JAG Corps has a spouse program that wherever you go, you are able to work as an attorney and get that special program within the Department of the Army as well.
I will tell you that I think it was my last trip back from Afghanistan, but my battle buddy was a Marine, and we always went over there together. You know, you watch each other and make sure everything's fine. And well, the last night we were in country, we were at a Marine base, so we wound up sleeping in the dirt. And again, that's not the Air Force standard. We don't like dirt, but yeah. But so we slept in the dirt, and I had my mobility bag open, and I, you know, took out my shaving kit. And anyway, we got up in the morning and showered in a cold shower, and took off for Kabul airport. In the airplane on the way home, it was a civilian aircraft, and they said, like they do on all civilian aircraft, you need to now declare whether or not you have any fruits and vegetables or live animals. And I kind of laughed. Of course, we don't have any of that. They didn't have fresh fruit anyway in Afghanistan. But I laughed and I said, no, and we turned in the card. Well, when I got home, you know, I really wanted about 24 to 36 hours of sleep. So I grabbed my shaving kit out and threw it in the master bedroom. When I got up that morning, I heard Linda say, hey, there's something in here. And it was a snake that I had brought back from Afghanistan. It was curled up, and our little poodle was in the best poodle point you've ever seen. But that's what happens. You just never know. But your spouse has to have a sense of humor. So I didn't mean to bring home a snake. It was a cute snake, though, and I asked if we could keep it, but they couldn't tell me if it was poisonous or not. Okay. And as has been mentioned already once, you know, children pay a price too. My daughter in 12 years from first grade to 12th grade went to 10 different schools because of all the changes of station. I was an Air Force dependent. I went to 5 high schools in 4 years before I graduated. I mean, that's just the way it works when your dad is moving around from country to country and in different assignments. Indeed, some schools even have rules about who can serve as a valedictorian. And what they do is they say you have to have been in this school, if it's high school, for 4 years. Well, that military members or their dependents aren't going to fit that bill ever. And frankly, I'm highly suspicious that that rule is out there to make sure that they don't compete with the local students, because military students tend to have a lot on the ball, and they're very sharp. And because of their experience in having served with their parents in some kind of role in the military. So my question is, to the degree that you have children or you served as a dependent, how do you deal with that? Or do you, Joe?
How do you deal with the strain on
with the
kids?
Children, yeah.
You know, again, that's part of the reason I left active duty, right? I didn't think that, to me personally, right, my family is the most important thing in my life. And it's very hard to balance the demands of the Marine Corps, which will, if you give the Marine Corps everything, the Marine Corps will take everything and ask for more, right? You can never do enough, truthfully. And I like I said, I left active duty because I didn't think I could give the Marine Corps everything and then still give my family everything that I wanted to give my kids. And I moved around a lot as a kid, and I just thought, I don't want to do this to them either. And so, how you balance it, truthfully, I mean, I see my buddies who have, right? You talk about different op tempos, and right now it's a lot better, but you look at deployed time and dwell time. And a lot of times when things are very kinetic overseas and we're actively deploying, it might be 6 months deployed, 6 months back home, 6 months deployed, 6 months on a ship, 6 months back home, 6 months deployed, where your spouse just carries on the life without you, and they have to be so strong to essentially be a single parent raising these kids in a place where they aren't, where they're not from. Their parent, you might be stuck in North Carolina somewhere where your family's back in Missouri. But the one thing that I think the Marine Corps does really well, which I know by the end of this talk you guys are all going to think I hate the Marine Corps, there is an overwhelming sense of a tight-knit community at these bases, and we take care of each other. And the spouses take care of each other. We have schools and childcare all set up for those reasons because we recognize the strain that is put on these families. And it could always be better, but again, you end up making do, and you realize, again, just the value of the strength of your spouse. None of this stuff is possible without them if you have kids.
Good, thanks.
Right.
What
Well,
about the Coast Guard?
no kids, and
No kids.
wasn't a military brat or anything. I'll just say from what I've seen of the people I work with, everyone handles it differently. So my supervisor is in at 8. She works extremely hard throughout the day so that she can leave at 4:30 on the dot to go pick up her kids. And everyone knows that while she's there, she's working hard. Other people, they come in and then they clock out, go pick up their kids, and then they take their work home with them. And they know they're going to be working at 9 or 10 at night,
Yeah.
But they set aside, I'm going to be with my kids from this point to this point every day.
Yeah.
So.
The hardest thing on my daughter, 10 of the 12 years, 10 schools in 12 years, was the 1 year, and I think it was between her freshman and her sophomore year, where she actually went back to the same school for a second year. And she didn't know how you dealt with that. So I didn't see that one coming. And I said, well, you're going to have your same friends. Well, she got very good at making friends quickly, and she's still very good at that. That's a skill set that's learned from, a lot of moving. But okay, great. Cat Murphy.
No kids either, just what I've seen. One of my supervisors, she's married to a high power executive, and I just wondered how she does that. And they have 2 kids, and she somehow makes it all happen. So yes, ladies, you can have everything. But yeah, her mom lives with them and takes care of the kids full time. So you do have to, there's just a lot of extra work or that you have to do on the front end, or maybe a willing family member to help out.
Yep, very good. How about you, Captain Rogers?
My child is too young to know how to deal with this yet. But I would just say, I think it's, to a certain degree, it's like any other job. It's just about using your network and making sure that you're there to protect them and just be the best parent that you can possibly be. I don't think that I'll ever figure that out. If I do, though, sir, I'll let you know.
All right, super. How about online?
No kids yet, sir. But I think one of the things that has helped me is being present, right? So if you're home, right, if you're having dinner and focusing on each other and making sure that that time is put aside, even if you do have to go back to work and send some emails out very late at night.
Yeah, my boss at Air Combat Command decided that we all needed SIPRNet, the secret internet protocols, in our quarters, which meant you're going to work until you drop, which is fine. But yeah, which meant after dinner you need to get back on the computer. Deployments are very tough on children and on spouses as well. So when you come back after being downrange for 6 months, the whole family dynamic has shifted. Mom's back or dad's back, And children oftentimes don't get that because they've had one parent that they've been dealing with, and now they have two. And it kind of, it's upsetting both to the child to a degree and certainly the spouses. The spouse that stayed behind is used to making all the decisions. And now, you know, the wife or the husband is back in town and that all shifts. So that becomes difficult. Completely different topic. What advice would you provide to law students considering a military career? I got to tell you, when I entered the Air Force, the selling point was that Linda and I could go overseas to Europe. And I could try a lot of cases and therefore build a good resume. And when I got back to the States, I could separate with that resume. I stayed on active duty because of the people I met there. And I really thought they were awesome. And that's the kind of client or people that I want to work with. And so I stayed until for 34 years because I was having fun that entire time. But what would you advise to law students that have never served in the military about whether or not to consider military service? Let's start online.
Sir, I would say that the JAG Corps is the perfect place to serve if you haven't served. It is a very tight community, and attorneys within the JAG Corps help each other a lot. So that there is that environment that is very positive, and it's just a great community. And if you have that question, just do it. Just go for it. Don't be afraid. You will get a ton of experience from the get-go, and you will deal with a lot of issues and complex issues that you would otherwise not see your first year out of law school.
Yeah, not too many people get to do the kinds of things that we talked about today. And that's kind of important. You're never going to do targeting in a civilian capacity. I hope you don't. And, you know, and so some of the things we do are extremely challenging. And every issue for me for the first 10 plus years was an issue of first impression. And so you get to do a lot of research. And my first base, I was the youngest one there, of course, but the next youngest one had been on active duty for 4 years. So I had a plethora of advisors around me, and I couldn't make a mistake. I just walked down the hall and see who had a door open, and they got my question. So how about you, Captain Roger?
I would say, number one, and I know I speak for everybody that's here on the panel, is network, right? So we can talk anytime that you want to talk about what opportunities are available in the JAG Corps and getting involved in externships, internships, shadowing, those types of things. But you also need to recognize and understand that there has to be a desire to serve, right? Serve your country specifically, right? Because there are sacrifices that you're going to make wearing the uniform that you would not make in a civilian capacity, right? And you're going to have things like your housing and your health care and your pay taken care of. But there are going to be times when you're gone. There are going to be times where you have to sacrifice. There are going to be times where your family has to sacrifice. And so if there is not a desire, a drive inside of you to serve your country, maybe the JAG Corps isn't the best thing for you. And if you want to talk more about that offline, happy to do that.
All right, very well. Captain Murphy.
I would say the JAG Corps has taught me so much. I love almost all the people I work with. Just great attorneys and great people that are willing to share their experiences with you because someone shared with them. And yeah, just the opportunity to travel, maybe go on an exercise overseas. You'll get a lot of experience very quickly, a lot of different kinds of experiences. As far as giving advice goes, if you do join the JAG Corps, make sure to invest in a very good air mattress because you might be sleeping on it for a month while you wait for your household goods.
That's right. All right, very good.
Alrighty.
All right, what do you think?
I did buy an air mattress, yep, and I did sleep on that, yep, because my household goods were delayed because of COVID for 3 or 4 months. But yes, my advice would be to do an internship. That's what I did, and it really gave me a glimpse into the world, got me in that door, familiar with the people, the organization, the mission, and I really enjoyed that. So that would be my first step, and that way you can see, is this the type of environment, the work I want to do without the long-term commitment? And like everyone else said, network, pick our brains, ask us anything. We'll definitely let you know anything we can. So that's my advice.
Very good. Joe?
I'll give my advice specific to being a judge advocate in the Marine Corps. If you're considering being a judge advocate in the Marine Corps, you got to go into it with open eyes. And what I mean by that is you don't join the Marine Corps to be an attorney. You join the Marine Corps to be a Marine. And every branch is different. I'm obviously biased. But your expectations of a Marine are substantially different than your expectations as a judge advocate in the other services. You go through 9 months of training before you go to Naval Justice School with some of our sea services. So you spend 10 weeks at basically boot camp, and then you spend 6 months training to be a provisional rifle platoon commander. Our physical fitness standards are very high and enforced for a reason. And the Marine Corps' mantra is kind of, you do more with less. So again, the reverse psychology really works with a lot of people, obviously worked on me. It's like, oh, you walk into the recruiter's office and they say, like, oh, hey, I'd like to be a Marine. They're like, what makes you think you can be a Marine? Sure. You're like, ooh. But anyway, the advice I would give you is if you are considering it, that you need to know what you're getting into. Your spouse needs to know what she's getting into, what her expectations will be. And you have to be ready to commit to leading Marines. It's not about being a judge advocate. It's not about getting courtroom experience so you can punch out after your first tour to become an AUSA. It's a sincere commitment to make Marines' lives better. That's why you become a Marine officer. So if it's for any other reason, please don't join the Marine Corps, all right? But there's a lot of great experiences, a lot of great opportunities, and a lot of amazing people in the Marine Corps judge advocate community.
We'll take you in the Army, though.
Yeah, right. The Army will take you and give you like $100,000 to repay your law school loans. The Marine Corps will not.
When I was at our strategic command, my deputy was Navy. And I always knew when he was interviewing a potential JAG officer because he came in the Navy whites. And the reason is because on the show JAG, they wear their Navy whites. And he knew how much, those candidates wanted to see him in his whites. And so one day I said, you ought to let me interview some of these. And he said, I will when I find one we don't need in the Navy. So, and of course that never happened. I agree with all the comments on service. If you don't have service up front, then you don't belong in uniform. Beyond that, there are a couple of really positive character traits that it teaches us. One of them is the ability to speak truth to power. Lean into the wind. When you're dealing with commanders, for example, and they're about to make a less than optimal decision, or even in front of a military judge, and you need to point out to the judge, well, Your Honor, you forgot this case or whatever, and you can do that with respect. And so when you get out of the service, that doesn't go away. You're always ready to, again, lean into the wind with whomever. And I've had to do that with some groups downtown, to include the city council. And it's a good trait to have. So that's really what I wanted to cover today, and I see that we're out of time. I'd like to thank all of our panelists for their attention to all the detail, and certainly online as well. And you guys are off to great careers. I will promise you the thing you're most proud of in the service hasn't happened yet, okay? So I can guarantee you that, but it will. So that's what we've got, Professor Drake.
Thanks. Thank you, General Harding, and our panel, Sergio. It's just, I get very maternal sometimes with my students, and I want to hug them all very much. It was just such a wonderful day. I thank everybody for being here. None of this would be possible without extraordinary staff in our clinic. Aaron, Ethan, Madeline, Eugene, Justin, Julia, Martha. Nikki is our new admin. She's been here like a month, and she had to jump way deep. Mary Furking, all the clinical students from the fall 2021 class really did an extraordinary job getting this off this year. So we thank you for being here. Please fill out your CLE forms. We're going to have cocktails in the fireplace lounge now if you want to have something to drink before you leave. We have soda as well, so please join us. You'll walk out and go around the corner and you'll see the fireplace lounge, and we hope that you'll visit with us there. But thank you for coming to the symposium. Thank you.